Great. Welcome to the regularly scheduled meeting of the Blue Ribbon Commission on the Future of the California Bar Exam. I'm Josh Pertula. I am was the vice chair and now chair of this commission. As many of you know, we want to thank Justice Guerrero for her time and her leadership. She's on to greener pastures. And so I'll be taking over as chair. I apologize if it's a little awkward. Don and I are at a table with screens on both sides. So you're going to see me turning and not looking at you. That's just the setup they have for us here. Let me just begin with chair's remarks. I believe that everyone would agree that we have made some real progress over the last couple of meetings, setting in on recommendations, both on how to proceed with the California specific exam, developing recommendations on a non-exam pathway. And today we're going to take some time to focus on the exam pathway. Specifically, we'll get into what questions we're going to work on and what we think we need to answer. But before we do that, I'd like to call for public comment. Devin, are you going to be calling public comment today?
I think Amy's going to assist and I will be doing the mic.
Okay.
But Chair, I think we need to conduct a roll call.
Let's do a roll first. Thank you.
All right. Susan Bakshian.
Present.
David Boyd.
Present.
Alex Chan.
Present.
Charles Dugan. Jeremy Evans. Jackie Gardina.
Here.
Ryan Harrison.
Present.
Dr. Henderson.
Present.
Esther Lynn. Tracy Montez.
Here.
Judge Reiser.
Present. Good morning.
Good morning. Natalie Rodriguez.
Present, but I'm gonna have to sign off and sign back in. My computer is acting weird.
All right, thank you. Kristen Rosie.
Here.
All right, Emily Scivoletto.
Here.
Karen Silverman.
Here.
Mylyn Spencer.
Here.
All right, and Amy Williams.
Present.
Hi, Amy. Jeremy Evans here.
All right, thank you, Jeremy. We have quorum.
Thank you. So as noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure the commission would have time to consider those comments. The commission has received all the written public comments. We thank the public for that. Let me walk through the procedure for a moment for folks. Amy, if you can call members as in the order they appear, we ask that you limit their comments to 2 minutes to facilitate the hearing from as many members of the public as possible. I encourage folks not to repeat points that were made by previous speakers. That'll allow the commission the time needed to deliberate on important topics. And we're going to have a maximum of 15 minutes of public comment today. Some logistics for raising hands. For those of you participating via Zoom, you should have a function for virtually raising your hand. It's the hand icon, usually at the bottom center of the screen. Those on the phone, you can press *9 and you will be called. We'll enable your mic when you're called. Amy, do we have any public comment today?
Yes, we do. We have one hand raised in the public. And it's Benjamin Cohn. So when you're ready, Chair, we could let Mr. Cohn speak.
Yes, let's go ahead. Thank you.
All right, Mr. Cohn.
Thank you. I wanted to speak in support of the agenda consideration for out-of-state attorney pathway. I think it would be a very good idea if those given a moral character determination and with a qualifying MPRE score could, if licensed out of state, have a more streamlined pathway on either of the non-exam supervised practice or MCLE options, or with regard to the California bar exam not needing to take that. and especially if they'd been practicing more than a certain number of years, as a number of states allow on motion. Secondarily, I wanted to speak in support of the idea of having hybrid exam and non-exam pathways to California licensure, even for those not licensed yet to practice law in any state. But at the same time, I wanted to make sure there was consideration given to not having the other pathway be an excuse to not make both pathways, whichever one the applicant chooses, accessible equally to those with disabilities. And so they aren't told that the option to do the other pathway is a reason that it's not necessary to fully accommodate them on the pathway they're attempting. That's all for today. Thank you.
Thank you, Mr. Cohn. Josh, we have one more person wishing to speak, Claire Salat. Claire, when you're ready.
Good morning. This is Claire Solat from the Legal Service Funder Network. And today my comments are tailored specifically to the work that you're doing with regards to the exam. I know that you have wonderful representation on this committee and others from law school faculty and staff, but I also want to just make note that the LSFN is very fortunate in that through our fellowship program, we have relationships now with, I believe, 9 law schools, including 2 California accredited law schools that are joining us this summer. And in talking with those deans and administrators, they are very excited and interested in knowing about the changes to the bar exam that will result in possible changes to their curriculum, allowing them to do more experiential work and allowing law students to focus on the areas of law that they hope to practice in rather than the old bar exam format of memorization. So happy to offer my resources, and I'll be back next month to discuss the recent survey that we did with LAC that specifically addresses the pathway to licensure. Thank you so much for your time.
Thank you.
Amy, in this new world of the way we're doing meetings, I just want to make sure that there's no members of the public at any of the physical locations that have public comment.
Josh, we're only at one physical location. So in the Los Angeles office, if you don't have public members, that's all the public comments that we have.
Okay, thank you. Okay, I'd like to move on to item B, update on the Blue Ribbon Commission charter at this time. I think that one of the things that I have been struggling with as a commission member up until this point is we're dealing with a pretty broad charter and figuring out what the expectation is, how detailed the Board of Trustees and the Supreme Court is expecting from us. And I think many of the other commission members may also be. So we had an opportunity to speak with staff from both the Board of Trustees and Supreme Court in trying to create a more specificity around some of our decision-making, especially today and again in our next 2 meetings, which will be non-exam pathway focused meetings. And so with that, I wanted to report back that we're really going to focus on 4 items today around the exam. That's item 1 is going to be knowledge, the subjects to be tested, and we're going to focus on CAPA and doing that. Item 2 being the skills to be tested, and again, we'll rely on some of the work good work that's been done before us in the CAPA study. Item 3, the percent of exam that is testing knowledge versus skills, and hopefully on each of these items we're going to be able to come to some agreement and resolution, end with a motion and be able to have some feedback. And finally, the 4th one, the exam requirements for foreign and out-of-state attorneys. I know an area that we've touched on and talked about a number of times already as a commission, and something I hope we can get a little more clarity and decision-making on. We will have similar guidance on the non-exam pathway. I don't think we're going to spend the time going into that at this point. We do have the next two Blue Ribbon Commission, full commission meetings will be on this issue or on these issues around non-exam pathway. As you can imagine, those take quite a bit of exploration. I hope that that these recommendations and these specifications are going to help guide us today. I think that it'll get us a little more direction. And with that, if as we go through this and it's determined that we need to have a amended charter or mission based on kind of our findings and our what we focus on, we'll bring that back to the commission for a conversation about it. Amy, I think at this time, it probably makes sense to turn to the first item of business. And what I'd like to do is just do a quick update on schedule. One of the main changes you're going to see between me and Justice Guerrero is I don't have the intellectual stamina she does. So we're going to break for lunch, probably around 12:30 between the two items. And we'll do that for a short period, 20 to 30 minutes, give people a quick break and come back on business item B. With that, Amy, do you want to introduce the first business item?
Yes, I will do that.
Thank you.
Because we're going to talk about the exam and the exam scope, I thought I would start today's discussion with a layout of what the current the bar exam looks like. So can we go to the next slide, please? All right, so the bar exam of today is a 2-day exam. On day 1, we have our essay, we call the California portion of the exam. We have 5 one-hour essays and 1 90-minute performance test on day 1. And on day 2, this is a portion of the exam that we procure from the National Conference of Bar Examiners, the multi-state bar examination. It's 200 multiple choice questions, and they're split into 2 separate sessions, 100 items in the morning and 100 items in the afternoon. Also, in terms of the topics that are covered at the exam, on the next slide, these are the 13 subjects currently on the bar exam. And as you can see here, the ones that are asterisks. So the asterisks here refer to the scope of civil procedure. So civil procedure includes the federal rules of federal procedure and the California Code of Civil Procedure, but not the California Rules of Court. And the subjects noted with a pound sign next to professional responsibility, that indicates that applicants are expected to know the ABA model rules of professional conduct and the California rules of professional conduct. Both of those are within the scope of the exam. So we're going to talk about the bar exam subject areas. So I just want to highlight what the current structure of that exam looks like. Any questions about the current format? All right. So with that, I'll turn it back to Josh.
Okay, great. Thank you, Amy. So we're going to start with Dr. Merritt today. I don't know if, can't see if Dr. Merritt's joined us yet or if she's available and we can bring her into the meeting.
All right, we are checking 1 second.
Okay. So just as some background, what we're looking at, I think folks will remember that we previously heard from Dr. Merritt. She helped us with regard to recommendations on how to assess minimum competence. She's currently serves on the NCB's Content Scope Committee, and today we'll be spending time specifically on how to make written exams more fair, reliable, and valid. And she's quite involved in the next gen exam content specifications and development.
Josh, Dr. Merritt's scheduled to join us at 10:30. So
I'm actually here, Amy.
Here. Okay, sorry about that, missed it.
Just in time if you want to go ahead now, whatever's good for you.
No, this works, absolutely. Thank you.
Yeah, thank you for joining.
Wonderful. Well, thank you very much for inviting me to speak with you. Let me see if I can share my screen. I think I should be able to. Here we go. And then, there we go. Okay, so I understand that one of the options you have in mind is developing a California bar exam based on the knowledge and abilities that were identified by your California attorney practice analysis. And that's a terrific basis for an exam. I've cited your analysis in several of my works. It's really a terrific foundation for licensing. And California has long been a leader in licensing. We all look back to your innovation with the performance test and with other types of work. So I'm really excited that you're thinking creatively about the bar exam, and I'm happy to share some guidelines with you. Let's start with the 3 commandments for any licensing exam. I'm sure you've already heard about these and talked about them, but just to put the rest of my comments in context, an exam obviously must be fair. It should be accessible to all test takers. It should not discriminate on the basis of characteristics that are irrelevant to the knowledge and skills being tested. And the test and testing process should also treat test takers with respect. Second, the exam should be reliable. That means that scores are consistent over time and versions of the test. So if you have a candidate who has the same knowledge and skills in February as they had in July, the candidate should receive similar scores on both administrations. And the exam must be used for a valid purpose. That means that there's both evidence and theory supporting the use of test scores for the proposed use. With a licensing test like this, then the exam should assess the knowledge and skills needed for entry-level practice. You've already taken a major step towards achieving all 3 of these goals with the California practice analysis that you've already conducted, because you've identified the knowledge and skills that new lawyers need, and you plan to build any exam around that foundation. What I'll do in the rest of this presentation is to go quickly through 12 other guidelines that I think are useful in creating the most fair, reliable, and valid exam to licensed lawyers. First, for better or worse, it's time to retire the traditional essay question. This may surprise you because essays are such a staple of testing. They certainly still dominate in the law school world, although we're starting to phase them out as well. The reasons for this is that practicing lawyers write lots of things, but they don't write essays. They write emails, memos, client letters, motions briefs, lots of other documents. And if you substitute these more authentic formats for essays, you immediately enhance the validity of the exam because you're testing an authentic type of writing rather than one that's somewhat artificial. You can still test the same things that essays test: issue identification, writing, analysis skills, but you'll be using an authentic context. And this may also increase the reliability of the exam because grading of essays is notoriously unreliable. There's a lot of disagreement among people who read essays. That can be improved by using rubrics and by having the graders consult with one another. But since your graders are all lawyers and they're familiar with formats like emails or client letters, if you use those formats, it becomes easier for them to agree on what minimum competence is. So you can enhance reliability this way as well. Second, in any written exam, it's important to reduce the testing of memorized rules. I think many of us didn't realize how many memorized rules the exam has grown to test over the 50 or more years that we've been administering the modern bar exam. But for almost that length of time, dating all the way back to a study that was done in California in 1973, we have research telling us that memorization is not really very important in law practice. In the Schwartz study, which was quite a good study done 50 years ago, the author surveyed California practicing lawyers. Only 4% of them said memorization was essential. Almost a third said it was not at all useful in their practice. More recently, the national study that I did with Logan Cornett, using focus groups around the country, found strong agreement that relying upon memory as a new lawyer is, quote, a bad way to practice law. As some participants put it, a few used even saltier language than that I won't repeat here. Now, that's surprising to many people, to practicing lawyers, because all of us who've been in practice for some time do rely upon a lot of memorized rules. So here's a quick explanation from cognitive science as to why it's true that memorization is over-tested for entry-level law practice. Lawyers actually develop their expertise somewhat differently than professionals in other fields. They are familiar with many, many concepts. We cover a lot of subjects in law school, more, I think, than any other profession does. As a result of that, lawyers recognize issues from all of these different subjects that they have covered in law school, and also know how to research the details that they need about that issue. If I have a landlord, if I have a tenant who comes to see me in Ohio, I currently know nothing about Ohio landlord-tenant law, but I would immediately spot several of the issues based on the property courses I took many years ago, and I could look up the Ohio law on that. Now, over time, as we work with the same subjects over and over again, we do remember those details. If I set up a landlord-tenant practice here in Ohio, within a few weeks, I won't need to look up some of the details about landlord-tenant law. But that's different. That acquisition of details through hands-on practice is something that sticks with us. Trying to memorize those details for an exam that's administered once is learn it and lose it. It's not productive in terms of entry-level practice. In fact, it's not particularly wise. New lawyers told us about mistakes they made when they tried to rely upon memory. So just to follow up on that, why did we develop this pattern in law? Well, the number of legal rules is vast. Even though we learn a lot in law school, we won't possibly learn all of the rules, particularly because they differ from state to state. They also change over time. As a result of these characteristics of law practice, this is one of the many reasons why most lawyers do not dispense advice in a single client meeting. There are some times when you will dispense advice in a single meeting, but that's not the norm in law practice. We tend to engage with our clients over 2 or more sessions before we would come to resolution of a problem. So if we reduce memorization on a written bar exam, that will increase the validity of the exam because it will test the knowledge and skills that new lawyers actually need. As I'll show you in a few minutes with new question formats, you can do more testing of analysis and of issue spotting if you're not always testing for memorized rules. And secondly, it greatly increases the fairness by reducing the need for expensive preparation. The memorization needed for the current bar exam is Herculean. I have seen some spreadsheets that recent graduates have put together, and the rules that they're memorizing number up to close to 1,000, which is not really a feasible task for the human brain. So this requires months of practice and drills. Successful candidates, as you know, purchase expensive prep courses and forego income for 2 or more months in order to engage in this preparation. As a result, success on the bar exam does correlate with financial resources. There was a study that was done for the New York Board of Law Examiners with a very large number of test takers over several years that showed that correlation very strongly, stronger than LSAT scores or the law school that attended. Simply having the financial resources to prepare is a strong predictor of success on the bar exam. Now, for this and other reasons, I don't know how closely you've been following NCBE's work on NextGen. As your moderator explained at the beginning, I've been doing some work with them, although I'm not an inside NCBE person. I'm an independent consultant. But they are, in fact, greatly reducing the amount of memorization that will be required for that exam. They recently released their content outlines for the exam, which are proposed drafts. A comment period is open, I think, until April 18th, and I encourage you to look at the outlines if you're interested and submit comments. But they have eliminated they've eliminated a couple of subject matters entirely. They have, within the remaining 8 subject matters, eliminated particular rules within those areas. And then they have also distinguished between things that somebody needs to recall for the exam and things for which they only need to be familiar, so that they could answer a question like, what is the issue that you would first research on this? Or they could answer a question when provided with the rule of evidence that they would be interpreting. So I think you may find that instructive. And I suspect California can be can do an even better job than NCBE, but you may find it instructive to see how they have started to reduce memorization on the exam. So if you eliminate essays and reduce memorization, what are you left with? Well, one answer is performance tests, which you've used for many years in California, and in fact, pioneered the idea, I believe. As I think you all know, these tests, these questions give candidates information about a client in some form, and then they also give a small library of cases, statutes, regulations that are relevant to that, and ask the candidate to produce some sort of authentic document. Sometimes it's a letter to the client, sometimes it's part of a brief, it could be a motion, could even be part of a contract. So these tasks are highly authentic, mimicking exactly what new lawyers do in practice. They have a problem and they have some resources to apply to that problem. In fact, in our focus groups, many of the new lawyers said, on my first day of practice or my first week, I got an assignment. I said, this is just like the performance test, what I'm being asked to do. So these are highly valid types of questions. They're also capable of generating a substantial degree of reliability, much more so than essay questions. This can be done both by creating strong rubrics that examiners agree upon before they're doing the actual grading. And it's also easier for graders to agree on what is competence, because again, this is a very authentic product. It's different than saying, does somebody who's written an essay show minimum competence? Instead, you can say, if this actually appeared in court or if this were sent to the client, would this indicate minimum competence? More intriguing, there is some evidence now that these questions may be more fair than either essays or multiple choice questions relying on memorization. LSAC, who, as you may recall, produced the LSAT, but is also involved in other types of assessment, has done some experiments lately with performance tests that are provided to students at the end of their first year of law school. They've done this just as a pilot study in about a dozen law schools, I believe. And in the study that they've done, they have found that the gap between white students and students of color is reduced by half on these performance tests as compared to first year grades they've gotten from the same students or their LSAT scores. So it's just one study so far, preliminary, but there's some indication that these types of questions may be more fair in ruling out characteristics that are not relevant to law practice, whether it's the expense of preparing for traditional exams or the stereotype threat that comes from traditional exams. There's something very interesting to research here about fairness. But even without that, I think that the increased validity and reliability are enough to make you quite interested in performance tests as part of any written exam. Now, there are some scholars that actually advocate using only performance tests on the bar exam, or perhaps requiring candidates to take a series of performance tests during and after law school. And that is a promising way to structure licensing. But other test makers, including NCBE and perhaps California, do want to maintain some multiple choice or short answer questions. Those can increase coverage on the exam. They can reduce the amount of time spent grading, and that can also increase reliability. So how would you reduce the need for memorization on those questions? There's a couple of different options. One is to create a standardized reference set. So this would be a set of the rules that would be tested on the exam, not saying we're going to test what the restatement third says about torts, but actually listing what the specific rules are that would be tested, that candidates would have before the exam to study and also would have available to them during the exam. I wouldn't recommend allowing candidates to prepare their own materials and bring them to the exam. That's an attractive model in some ways, because actually learning to do that, to prepare your own materials, can be an important part of being a lawyer. But it increases too many problems in terms of fairness. Candidates who will now then purchase from bar review companies even more expensive materials that are designed to be taken into the exam, and can also raise questions about cheating and reliability on the exam. But a standardized reference set is something that is possible to do. Interestingly, NCBE is actually going to test this out with respect to the rules of evidence. They announce in the content outlines that they've published that they're going to do some research giving people, not on the actual bar exam, but in pilot groups, evidence questions with the rules provided and without the rules provided. And they want to see what the results are in terms of achievement, whether or not there are differences among demographic groups, and in general, how this would work. So this is an idea that I think you'll be hearing more about, and can, in fact, increase the validity of the exam by testing familiarity and analysis, which are the skills that new lawyers need, rather than memorized recall. It's an approach that doesn't affect reliability, and it almost certainly is more fair because it will reduce the expense of prep that goes into memorizing rules for the exam. A fifth guideline is to consider the use of very short answer questions instead of some or all of the multiple choice questions. A very short answer question is really a multiple choice question without the choices in most cases. Here's two examples that there might be a fact pattern, and you would ask which hearsay exception will admit the statement, rather than asking someone to choose from among four choices, or which element of the crime will be hardest to prove here. The reasons to use short answer questions, interesting, they increase validity because law practice requires us to come up with answers, not choose among possible answers. They are just as reliable because they do generate objective, correct answers. In fact, much of the time this can be computer graded. I've done this with an online simulations where you put in all of the phrases you can think of that would be correct. And if somebody answers something that's different, you then just have to look at those answers. But most intriguing, there are some signs that these questions reduce the disparate racial impact of multiple choice questions. That's just a few articles in research outside of law, but this is something that I would personally like to research further. I'm hoping that NCBE will, and if they don't, I may do some independent research on it. It is true that these questions are harder for everybody. Fewer people will get them correct than if you gave the same people an equal number of multiple choice questions. But the gap between white students and students of color is not as large. It shrinks quite considerably in other fields that have looked at this. This may have something to do with the stereotype threat that multiple choice exams evoke. It may have something to do with the confidence level that people feel in a profession that has long welcomed them versus is still only starting to welcome them. It's just an intriguing thought. The other reason to use these questions is that they lend themselves quite well to integration with other types of questions, something I'm going to talk about in just a few minutes. Well, forgot to show you that slide while I was talking, but there's a summary of what I just said. So the sixth guideline is to test more skills. That's something that I think you've already concluded from your practice analysis. What I've done here is to list the 6 skills that your working group pulled out of the practice analysis. And then I would strongly urge adding the 7th, negotiation, which was the one I think that was just cut off in terms of its frequency of use or importance in the practice analysis. It will be on the next gen exam. And I think it's a skill that cuts across all practice areas. As some new lawyers said to us in the focus groups, even if I'm not negotiating on a client, I have to negotiate with the partners about how much work I can do for each of them. So this is a skill that I would consider including. Now, you can test some of these skills through performance tests, but you probably will want to adopt some new question formats in order to test them. Here's some examples of the kinds of formats you can use. These are some of the things we've been talking about with NCBE, and the sort of imagination is the limit here. There are lots of different ways to test these skills. We can't have candidates actually engage in a client counseling session or a witness interview on a written exam, but we can give them part of a transcript and ask them to critique that. We could even, if we want to put a few more resources into this, create a video that they would watch and then critique the video afterwards. We can also ask candidates to outline a negotiation plan. Unless you're a very experienced attorney, you don't usually enter a negotiation without some sort of plan, without thinking ahead of time. What are the strengths and weaknesses of your case, which involves both the doctrine and the sort of equitable sorts of factors, the mitigating sort of and extenuating circumstances, what are the interests of the parties, and so forth. You could ask people to develop a research strategy. Research is somewhat difficult to test on the exam because, at least NCBE is finding it difficult because they don't want to open up the exam to either the internet generally, excuse me, or to just one commercial database. So they're not going to test research in the sense of saying, research this issue, here's a database or here's the internet. But one can give candidates a problem and then say, what's your strategy? What are the types of resources you would go to? What are the ways in which you would phrase a question in a online database, and so forth? You can, as I think the bar exam sometimes currently does, give candidates a contract and ask them to critique it or to revise a portion of it. You can also do something that I call a trial grid, although it's useful for more than just going to trial. This is what I mean by a trial grid. We use these in the clinics that I taught, and I think that many practicing lawyers use them if they're involved in any sort of litigation. In the grid, you list in one column the elements of the cause of action or the crime. You would use a separate page and grid for each cause of action or crime. In the next column, you list the evidence that is available to support or refute that element. And this is something we do even at the very beginning of a case to highlight where we have gaps in the evidence that we may want to pursue. The third column involves the objections that might be raised to evidence and then arguments that could be made against the objections. And in the final column, the story that we're trying to tell. Even when we go to trial, we're not just meeting the elements, we're trying to tell a story about our client that goes along with those elements. So filling out this type of grid, we're thinking about this in some of the prototypes for NCBE, as I'll show you in a few minutes, how effectively it combines testing both skills and doctrinal knowledge. So these types of questions are very efficient because they test skills that we already test on the exam, like issue identification, analysis, and writing. All of those are going to be tested in a negotiation plan, for example, but they add new skills. Like to the negotiation plan, we now have to add thinking about what your BATNA or best alternative to a negotiated agreement would be, what the interests of your client are, and so forth. There's lots of creativity that could be applied here to designing prototypes. In fact, I encourage, if you get into this, any of you who are practicing lawyers, think about the tools that you use in your own practice. What are the tools that real estate lawyers use that would be comparable, for example, to my trial grid? Using these new types of formats advances all three of our licensing commandments. It adds validity by more closely tracking the skills that new lawyers need. Many of these formats lend themselves to rubric grading so that they can produce high reliability. They can be quicker to grade than reading through an essay or a lengthier memo that somebody is writing for a performance test. And we may find that these formats are also more fair to candidates than some of the existing testing formats we have. You could take questions like these and arrange them in what we might call a work basket test, where the candidate has the experience is similar to coming into work and you take one item out of your in basket and you work on it for half an hour with a variety of these different questions attached, and then you put it in the out basket and you take up the new task. So it's more engaging, it's more like the actual practice of law. It might reduce the stereotype threat that's associated with taking high stakes exams. And these questions are fun to create. I've been creating them based on some of my old clinic cases. Now, before we leave this topic of skills, let me address a question that I know you've been thinking about in particular. What percentage of the exam should test skills and what percentage should test doctrine? Now, my answer to this is going to sound quite facetious at first, but it is serious. All of the questions should test doctrine and all of them should test skills. This is already true, at least in theory, with the current exam, because a multiple choice question is supposed to test the recall of the doctrinal rule and then the application of that rule to this new set of facts. So it's both doctrine and one particular type of legal thinking. In the same way, a performance test is going to test familiarity with basic doctrine. You may not have to recall the details, but you won't get anywhere with the sources in the file unless you understand the foundational concepts in that field. And then it combines that with the analysis, synthesis, and writing that a performance test would provide. The key to incorporating more skills in the exam is to expand the skills that you're testing by expanding the formats in the different types of questions. So to demonstrate that, here's some examples. If you're critiquing a client counseling transcript, there might be incorrect statements of doctrine there that the test taker would have to pick up, or a place where the test taker did not get, where the sample person, the transcript that we're critiquing, where the person did not give sufficient detail or did not answer the client's question with the right type of doctrine that the client really needed to know. There will also be examples of poor counseling technique, places where the lawyer ignores what the client is asking for or is too abrupt with the client. So this one transcript will test both doctrine and skills. Same thing with a negotiating plan. You can't develop a negotiating plan without understanding the law that is cabining your dispute, but you also need to use specific negotiating skills. You have to be able to identify the interests of the parties is in addition to what the law might specifically give them. And you have to be able to identify your client's reserve point, their best alternative to this negotiated agreement, and so forth. Or if you recall this trial grid that I showed you, look at the way in which this integrates, as law practice itself does, both doctrine and skills. When you're identifying the elements of the cause of action, that's primarily doctrine. Although if I give you a statute, then it involves some skills of analyzing the statute to pick out the elements. When I'm matching the available evidence up with the elements of this cause of action, that's mostly skills. It involves my analysis of the facts that I have and by pairing them with the underlying elements. It may also involve some fact gathering skills. You can't go out and gather facts while taking a written exam, but the exam might ask candidates to say, what are the additional facts that you would be looking for on this particular element? When we get to objections to the evidence, that's a lot of doctrine, remembering what the rules of evidence are, although it does also involve some analysis because we're applying those rules to these particular facts. And we may be thinking about creative ways that we could get around a particular objection. Maybe I can't introduce this document, but I could have a witness talk about it instead. And the story that we're telling is going to be largely in the skill category, although you certainly have to understand the doctrine to know what you can get away with in telling a story in court. So a good exam will really integrate both skills and doctrine. An answer at a different level is, because you may be thinking, okay, each question has both skills and doctrine, but how much weight do I give to each? Is to look at something like this grid and to think, well, how much of law practice is doctrine and how much is skills? And I would say that about 2/3 is skills and 1/3 is doctrine, if you look at this trial grid as an example. The doctrine is essential, necessary, but not sufficient. And when we really think about the whole range of skills that we're testing, they probably are more like 2/3 of what lawyers do and what you would want to see on a minimum competence exam. Okay, so returning to our 12 guidelines, and I think the remaining ones will go a little bit more quickly. The seventh one is to be transparent. California already rates very highly on transparency, but if you're changing your exam, going to a new format, you'll need to think about doing much more. I would create a resource that outlines the specific rules that candidates will be tested on and skills. This is especially important for new skills that you're adding to the exam. What exactly do candidates need to know about interviewing or client counseling? Are there particular approaches that they will be asked to follow? I know that lawyers differ in their approaches to everything, but there are some basics that we can give to candidates, and those would be the basics that we would be testing them on. I also encourage you to actually list the doctrinal rules that candidates should know. NCBE is moving in that direction. They haven't gone the whole way with these content outlines, but our committee, which advised them, actually suggested that they create the rule book, that rather than leaving this to bar examiners to create and then charge people for the rules that they need to know, if the test makers know the rules they're going to test, if you know which rule, what the particular consensus rule on nuisance is, just spell it out. Don't leave it for the candidates to figure out or the bar examiners to research and charge them for. And then also indicate which rules need to be recalled from memory and which ones require only familiarity. Again, the outlines that NCBE has just published give some indication of how to do that. In addition to telling candidates what will be tested, you would also want to provide sample questions if you're changing question formats. These guidelines, of course, line up with the requirements of validity and fairness. We need to know what we're testing before we test it. So having a very detailed outline of the rules that will and won't be on the exam is important. And this also enhances fairness if we share it with candidates at cost, because bar prep companies charge high amounts of money for that information. It was interesting when working on the content scope committee, I did, and I think other members of the committee did too, we borrowed bar review books so we would know what exactly the rules are that are currently being tested. And that seems sort of upside down. It seemed that the bar examiners themselves should be telling us what the rules are to be tested, not just the area that we're going to test you on homicide, but what specifically are the rules of homicide that would be tested. An eighth guideline is to think about time limits. I think often in both law school and on the bar exam, we simply take the time limits as given, that we have a certain number of hours, and then we write an exam that we hope will fit in a fair way with that, with those time limits. But I think we've done some research on that, but I think it's time to do some more research. Speed is not a part of minimum competence, certainly not the type of speed that is required on the bar exam. We depend much more on preparation and thoroughness in law than on shooting from the hip or being as quick on the draw as the bar exam would require. There's certainly a realistic limit that we don't want an exam that lasts for more than 2 days, but in creating components for the exam, it's important to do pilot research as to how much time it really takes for people to answer with minimum competence. If we have a lot of people who are failing to show minimum competence on a performance test that's timed at 90 minutes, but if we extend the time to 2 hours and then almost everybody demonstrates minimum competence, then we know that the test, the speeded test, is really testing speed and not a speed that would be necessary in practice. 2 hours would be a more authentic time for many of these tasks. So I think NCBE will be doing research. If California continues with its own exam, I hope you'll do research and that all of this research can come together to inform all of us. Again, this enhances fairness. That expensive test prep is focused many times around speed, learning how to respond quickly to these questions. We don't know, but have some suspicions that demographic groups may differ in how speededness affects them. So this is an important issue to research. The ninth guideline involves administration issues. You're probably already thinking about these. You need to think about computer-based or paper-based exams. If you're going to provide resources during the exam, how will you provide them? Will they be electronic? Will they be in written form? Those sorts of questions. What is the length of the exam? What is the timing? Would you like to break the exam up into multiple components, as some people have suggested? NCBE rejected that idea, but rather narrowly. There was a strong contingent that had urged having an exam that people could take broken up into components over time. 10th is one that you've already gone through in California, but unfortunately we'll have to face again, whatever you decide about an exam, because next gen will need a new cut score, and certainly a new cut score. California would need a cut score for a new California exam. I think you already know most of the drill on this from the work that you've done in the last few years. The few things that I would add are to require the standard setters to actually take the exam before they talk about the cut scores. That's something that's a kind of a gold standard in setting cut scores, and one that I think you would want to reach for. You will have a benefit if you create a cut score for a California exam, because you can use all question types. In the cut score study that you did most recently, as well as the few that other states have done, have been hampered by the fact that NCBE would not allow you to use the MBE questions. And the MBE questions are a major part of the exam, with the other portions scaled to it. You're able to work around that and come up with a defensible way of setting a cut score, but it will be much better to have a full exam to set the cut score on. And the other thing is, I would cast a wide net for new techniques. I have been reading a lot of the cut score literature, and so many of the approaches are developed for secondary school exams and for other sorts of standardized exams given in elementary and secondary school. And it's much easier to decide what minimum competence is in that level. At that level, I think that high school math teachers know what they mean when they say minimum competence in algebra. It's harder, I think, in a profession like law. So we may want to be creative in talking to psychometricians about different ways that we can set cut scores. These last two guidelines are particularly important, although they're ones that I'm sure you already have in mind. You'd want to incorporate diverse perspectives at every single step of creating a new bar exam. The participants, of course, should be diverse in any of the groups that are working on portions of this, and in particular should have strong representation from the populations that have been traditionally disadvantaged by the exam, people of color and people with disabilities. But just doing that is not quite enough. I've divided this into two guidelines because I think it's so important. Diversity does not always bring inclusiveness, because sometimes underrepresented people feel that they can't speak up and raise issues, or that they will have difficulty persuading the rest of the group of their perspectives. So the gold standard now is to recommend that any sort of process also include explicit audits for bias. So this would mean that at each stage in the process, let's suppose, for example, you have a committee, as NCBE did, to create the content outline. What exactly would you test in the field of criminal law or in evidence? You would have diverse members of that committee, but there would also be specific time set aside for all participants to talk about potential sources of bias. So we're going to talk today about how the decisions we're making might affect these different populations. And so everybody on the committee feels that it's on them to think about the implications that my decision to allow a reference to, open book for the federal rules of evidence, how is that going to affect people with disabilities? Will it actually be harder for them because they won't be able to access the materials as well as other people? If so, how can we deal with that unfairness and so forth? You could consider bringing in a facilitator for these sessions, although I don't mean to imply by that there would be something, a lot of hostility or fighting in these sessions. It's more that a facilitator may be somebody who could really make all of us think about what the implications of our decisions are. I think that's it for what I've prepared. I'm hoping that you'll have lots of questions or comments, which I'd be very happy to engage with.
Well, thank you, Dr. Merritt, for that overview. I'd like to open it up to questions. Commission members, if they have any. I think this is a good time. This will be the one time that we have to think about the kind of format, modality, timing, administration. Those aren't questions we're going to be answering today, but obviously they all will be part of the larger questions that we will be answering. So just to set the table for everybody, next we're going to walk through, after we ask questions and get responses, we'll spend some time walking through the CAPA recommendations with regard to knowledge, content, doctrinal rules, and then the same with skills. And so as you think about those issues that we're about to go into, if there are any specific questions for Dr. Merritt that would be helpful, now would be a great time to ask them. Amy, I'm going to go ahead. I can see the hand, so I'll go ahead and walk through these. So Jackie.
Thank you, Debbie. It was a great presentation. I really appreciate what you brought to it. Two questions jumped out for me. One was, we've accepted a 2-day exam as the norm, and I'm wondering if your research has looked into kind of the number of questions or the length of the exam. And the second one is, you identified a number of different types of questions that might be included. And I'm wondering if you're suggesting that it's important to have a mixed set of different kinds of questions, or an exam that was all MPT or the like. So anything you can provide in those ways would be helpful.
Sure. Unfortunately, I don't think there's any research on the best length of a licensing exam, although it's possible that Tracy knows something from all the other fields that she's worked in. There's a lot of, I think, sort of consensus thought that more than 2 days would be exhausting and perhaps inhumane if it's all done in a row. Quite a number of states did use to, including maybe California, used to have 2.5 days. That's what we had in Ohio. And that did seem to really tire people out. There are people who advocate for breaking up the exam. There are other professions that do that. Medicine, for example, has multiple steps in their exam. Accounting does as well. The arguments against that are, to what extent does that interfere with other things people are doing in their pathways? If you have to take part of the exam in the summer between your second and third year, is that problematic for getting in the work that one does? And then there's also the question of whether or not breaking up the exam makes it harder because somebody has to pass each component. The bar exam now is compensatory, meaning that if you do really well on half of it, that can make up for not doing so well on the other half. So those are all questions that one has to kind of put in the hopper and juggle. And I wish there were good research to say, do this one rather than that one, but it might be something that could be done through some pilot studies in order to get a sense of which way to try, and then to keep an open up mind about changing. In terms of types of questions, I advocate for either a full performance test exam, which I think is in some ways the easiest way to go towards a more fair, valid, reliable exam, because we already know what performance tests look like. But I feel equally good about, and might even prefer, what I've referred to as the kind of work basket, where you would have some items that, I mean, I've tried a few of these on a couple of colleagues. I can't unfortunately share them with you because NCBE is paying me for this work product, and I think I have to keep it secret until they're willing to release it. But I put together a question, for example, where it says, you know, you're a new lawyer in a criminal defense firm, and you're going to talk to this new client, and you're preparing for that. In the file, so far, all you have is the police report, which is what the prosecutor provided. And I actually used an actual police report, changing names and so forth. And then it asks a few questions about, you know, oh, you recognize there might be an issue. The client made some incriminating statements. Would you be able to suppress those? And one of the questions is, what would you ask your client? What are the questions you want to ask, which requires them to both think about what the in custody requirement means in specific terms, in the factual, and then how you would phrase it to your client. And then it has one or two multiple choice questions that are related to evidentiary issues. And then it says, oh, now you've gotten answers to these other things. And it turns out the client clearly violated the statute. Oh, there's another part where you pick out the elements of the statute and think about the evidence. And now you're getting ready for plea bargaining. What are your mitigating factors and your aggravating factors? So it's and the professors I've shown it to have said, gee, this is kind of fun. It's sort of engaging. It's like working on a real problem. So I think there's a big difference between facing a full day of 200 multiple choice questions on, on that move around from place to place, and that type of engaging that I think I would really encourage. And hopefully there will be more prototypes soon, or I will have time to create more prototypes that I could just float out there into the world.
Tracy?
Good morning. I just wanted to thank you for that presentation. As a trained psychometrician, I loved all of your points. Just very exciting, spot on. Definitely think we need to move away from the essay. Love the performance tests and that work in basket. It reminds me of assessment centers that we've done for law enforcement and fire service, where you get them in and you give them a series of problems that they face day to day. Super easy to grade in terms of very rigorous rubrics. Great reliability. So yes, very excited about all these points. I don't have questions. I just wanted to tell you that I really like this idea. Personally, I'm thinking a little bit more of a multiple choice, possibly earlier in the process, where you do specify exactly what the candidates need to study and have a reference. We do have that for like the architects board, where they go in, they take their computer-based test, they have a set of documents that they refer to, diagrams. It's great. And then maybe later coming in for a day of performance tests or work basket. But I really like the idea of letting candidates know exactly what they need to be tested on, and kind of narrowing things. Yes, there's great ideas to do things, but let's just pick a couple of new exciting things, focus on those and do them well. So that's it. Thank you for your presentation.
Great. Well, thank you. I admire all of your expertise in psychometrics, so I appreciate that.
Alex, do you have a question?
Yeah, thank you, Debbie. This is a very, very powerful, meaningful presentation. Appreciate you putting the time together to get this presented. I only have one question. Now, in slide 2, I think you mentioned about certain issues in connection with the essay formats, including issues surrounding subjectivity and the consistency, or really lack thereof, in grading between different graders. And then in slide number 6, you propose sort of a list of skill sets to be tested in the form of drafting and writing and counseling and advice and so forth. I envision that these skill sets, if indeed tested, would still be subject to grading inconsistencies and subjectivity issues. What do you suggest as far as how best to tackle these issues in the next generation of our exam?
It's an excellent question. The new formats vary in how much subjectivity they would include. If you have, for example, the critiquing a transcript of a client interview, or you may have less subjectivity there. But one of the things, and this is one of the things that actually I'm going to Minneapolis tomorrow for a 3-day working session with some NCBE people on these new format questions. And it's one of the things we'll be addressing. I think for some of the formats, what we would do is to say, let's talk about the mitigating and extenuating factors for a plea bargain, for example, that there may be 5 factors on each side, but somebody only needs to hit 3 of them because there are some things that people would see and some things they wouldn't see. And that you can, if you have somebody who comes up with something that's not on the rubric, you have a process for adjusting the rubric to accomplish that. I think with some of these, and I think we also need to be more specific with people about how we want them to write certain documents. One of the things that we did on the content scope committee and that NCBE accepted was we said, look, the current performance test says that there could be any type of document, including, and it names 12, and then you could imagine many others. That's not really fair to the candidates. We came up with 7 documents, and these are the documents that would be tested. And by document, I include a client email and a contract, so that people we can then give in the rule book, which needs a better name, but the rule book needs to have some specifics about how we expect people to write these things, because law firms differ in how they want to write their emails, but there should be a set of guidelines that people are following for this minimum competence exam. I don't think we'll ever completely eliminate subjectivity, but I think we can go a lot farther with both good rubrics and also the fact that if we're using more authentic documents, it's easier for lawyers to recognize minimum competence.
Thank you. Just one follow-on question. I know previously you said, or at least you would advocate the full performance exam, so no MBE or the essays. Are you advocating that we do away with the traditional topics that we typically put into the exam, so ranging from CITPRO or con law to contract and evidence? Or are you suggesting that we incorporate these topics into the performance exam?
I would incorporate the topics into the performance exam. I think that one could have a performance. The original idea of the performance test was to have a subject that somebody knew nothing about. You know, could you tackle an admiralty problem if you were given one? And NCBE seems to have moved away from that over the years. I think it would be possible on an all performance test exam, or even one with these mixed formats, to have one question that would be in a esoteric area so that you test the ability to deal with that. But otherwise, I would stick to the areas that I would pick 8 subject matters and stick to them.
Thank you.
Emily?
Thank you. Thank you so much, Dr. Merritt. This was extremely helpful. I've scribbled a ton of notes, so I thank you so much. This is just
I will provide the slides. Don't worry about that.
Thank you. So I have a couple of questions. One just relates a little bit to performance tests that California has given, but a while ago. So it seemed like California had done things like a discovery plan or develop, write a will, things like that. But in the last decade or so, it seems to have gone away from that and is more, here's an office memo or here's a letter to a client. So it sounded to me a little bit like we're thinking maybe like with the trial grid, et cetera, maybe reviving some of those things. And sort of to Alex's point about subjectivity, there are lots of ways to prepare a trial grid. There's lots of ways to do a discovery plan. And so I think what I hear you saying is if we are going to do those, we will need to very carefully sort of document or have a rule book about how the applicant is to produce at least the look of the thing. And then sort of the skills that we're testing and in both doctrinal and skills areas would hopefully be, well, obviously testable, but also in a narrow field of what could be provided. So I don't mean to speak for you. I just wanted to clarify that and kind of on the margins with some of these more diverse type of questions. How do we handle that issue?
No, I think you're absolutely right in what you summarized, that NCBE certainly, and California, if you go this route, will need to say, okay, here's the type of format question. You will get these trial grids, and here's examples of how they should be filled out. And then when people go into practice, they may find that their organization uses a different type of trial grid. And that should be something that we're all comfortable with. I mean, just as I use that grid for the students in my clinic, and then they go work for the public defender that wants something different, that happens. And I think we as professionals can cultivate this idea that there are certain basics that we might expect somebody who comes out of law school to be able to do. And then we teach them as professionals to move beyond those basics, so that the rule book doesn't become the template for all of law practice, but just for what we would expect. Medicine actually has this idea of what they call entrustable professional activities, that when your first day in a residency, your supervisor should be able to expect that you could do these 10 things. They haven't achieved it yet, but they have that expectation. And so this would be similar to that, we would expect you to do this in this basic way, but we would be teaching you to do it in other different ways.
Thank you. Oh, go ahead.
I was going to say, by the way, it's interesting when there's ways again in which the skill and the doctrine interacts. I realized, for example, when I did one of these examples, that when you look at a criminal law statute, you wouldn't necessarily pick out as an element that you have to identify the defendant as the person who did it. I mean, it does say any person, but that doesn't really jump out as an element. But I think it would be great for every law student to know when they graduate that in a criminal trial, you have to identify the defendant. So I would put that in the rule book, that if you're doing an analyzing a criminal statute, the first element is always, it's this defendant.
Thank you very much for that. And I guess the other question I have relates to, and this is a hard question, but it's something I've been thinking about, is where does bar prep go from here, right? So we have a lot of the companies that obviously, as you said, it's sort of upside down. Sometimes it drives what graders see on the exam because everybody's quoting, for example, a Themis rule or a Barbie rule or something. But I'm wondering, part of the issue that students have, I think, when they graduate law school is that they, at least in California, they're preparing for 9 to 10 weeks to take an exam, a 2-day exam in July, and they don't have the option of taking it sooner. And I'm wondering if you have thoughts about either the NCBE or California, but could we move away from a 10-week study period because memorization maybe is not part of it? Certainly there's going to be people who avoided litigation classes in law school that now have to beef that up. But any thoughts, I guess, on what this means for people who will be graduating and then having to study during that time?
That's a fabulous question. And I actually had not focused on that myself. It would be, I don't know how long it's been that the bar, it's certainly since 1980 when I took it, the bar has been at the end of July. But if there's less need for bar prep, it will be terrific to move it earlier in the summer. That would be a bonus for everybody, including having the graduates able to work for pay more quickly and the clients benefit from them. I sometimes joke that maybe if we succeed in all this, bar prep will become a course on negotiation and client counseling for the graduates of the few schools that still refuse to teach those things. But I don't know. The bar prep companies, have also bought out West Academics. So now law school techs and bar prep are all coming together in a very unusual way.
Yeah. Okay, thank you so much. I think that was it. I may have more later, but I really appreciate it. This was so helpful.
Great.
Dr. Henderson?
Yes, thank you. And I echo the compliments about your presentation and your 12 items. If I might, I would like to ask you to consider perhaps a baker's dozen and add field testing, rigorous field testing, as the test is designed and put together to make sure that the item types all function in the way that we intend. When we make changes to questions on a test, we normally think that we're bringing about some improvements, but we don't always improve them. In fact, we sometimes cause them to perform less well. So there are statistics, as you undoubtedly know, that can be generated to describe the way that questions perform. It's also a great opportunity to do things like differential item function studies to assess the potential of a item type or a test as a whole for fairness to a variety of cultures. Field testing gives an opportunity to assess timing. I recently had the experience of, I'm responsible for a clinical examination in dentistry, and COVID required the organization to change from an oral format that is spoken. I know we're talking about dentistry. Oral is a complicated term there, but a spoken examination to one that was written. And there was no opportunity to field test. And what happened there was that the organization, given the change in testing format, allowed double the time that it had when it was a spoken examination. As it turns out, that was an insufficient amount of time, and only the first administration was it was only through the first administration of the test that we were able to detect that. So had we been able to field test, then we would have had a fairer introduction to the test and allowed more of these folks to enter into practice earlier. I just can't underscore enough how important field testing is for any assessment, but particularly where licensure is concerned. And then just an endorsement of your idea to incorporate the legal topics into the skills assessment portions of the test. The working group that oversaw the CAPA study stopped short of designing the test because it was not in their charge. But when this question came up, can we possibly offer a test that covers a range of skills and a range of subject matter knowledge in a reasonable period of time. And the matter of combining the assessment of subject matter with the assessment of skills, so that we're really able to get at their ability to recall the information that's necessary, but then also to apply it in a problem-solving situation. I think I just really want to endorse that notion. So anyway, that's it. Thank you. No questions. Just I really want to make that suggestion to you.
Well, thank you very much. I agree entirely on field testing, and it's more than a friendly amendment to the to the dozen guidelines. I'm curious, in fact, if you have any thoughts, both from I'm curious myself, and maybe the committee would like to know about ways in which one effectively field tests something that's brand new. Do you find recent graduates before or after they've taken the current exam? It's something that has puzzled me.
And that's a challenge for everybody. You want people who are participating in a field test to be a match for the target audience for the assessment, which would suggest new grads. At the same time, they need to be motivated to exert their best efforts on the test. So it can't just be seen as a field test. So these are things that I think, and maybe Dr. Montes has more specific ideas than I'd like to put forward. I mean, I've certainly done a lot of field tests, and the way of accomplishing that is different from program to program. One advantage that we have here is that the state bar already administers a test, and it might be possible to augment the existing test as the new one is being developed with problems and questions that we're considering in the new model. That would be ideal because it addresses both of those concerns about the validity of the sample. That would be my first and best recommendation if it can be carried out, but also then having set of people who are recruited specifically for the purpose of being the field testing group. That's a possibility as well. So good question.
No, those are good thoughts. I suppose even one could think about it in a sense, introducing changes gradually, so that if you have most of the current exam and then you field test this type of mixed question format or something like that. So,
Yeah, that's very reasonable way to go about it too.
Looks like
Thank you.
Tracy wants to comment on this subject.
Please.
Yes. Briefly, I'll just add, it's a struggle with the motivation of the individuals taking the test. So I do really concur with Dr. Henderson about, that gradual change. If you've got a current situation, adding those kinds of questions, although sometimes because they look so different, then individuals will know, oh, these must be the pilot questions or the experimental. What we typically do at our department is we have pilot items mixed in, I should say new questions that are not graded, but they're not necessarily different types. When we have moved to using different types of questions, we may hold the candidate data and do an analysis to see if it negatively impacts, and we may introduce just a few at a time. And if they're performing well, then we'll add more of the new types of questions. So we really haven't made any significant changes per se in item types. It's typically gradual, as you both mentioned. Thank you.
One other thought I've had, if it's useful on this subject, most law schools now teach bar prep courses of their own in addition to the ones that candidates buy. And although the exam subjects might even be a little different, or the formats, it might be that students in those courses would be willing to take and get some benefit from taking a pilot test, because they're still kind of exercising their exam mentality and so forth. I've thought about, if I wanted to do some research, checking with my bar prep professor to see if she would let me get into her course.
Yeah, I think that's a great idea. And if I may add to, it would really be nice to see if we could get students to think of this as preparing for the profession and not to take the exam. I know that that's sort of the culture for law students, but we really emphasize that getting ready to take the licensing exam should just be another step into the profession. And if you have to take an enormous amount of time or pay a prep school to get ready to take the test, that's not good. The test needs to be more transparent. It needs to do a better job, because it shouldn't be something special. It should just be another piece of the process of moving into the profession.
Emily?
I'm happy to have Judge Reiser go first.
So thank you for that presentation. That was very impressive and very thought-provoking. So a lot of people like me are very visual. And so much of what you said, strikes a chord, but it's theoretic. So my inquiry is whether there have been model bar exam tests that have been formulated, not necessarily definitive, but to give people a concept as to what this might look like.
Well, the various formats I talked about are things that NCBE is going to publish prototype questions on. So there will be some examples to see, and they will be doing some type of pilot field testing on those. In terms of other examples, not really within law. If you think, for example, if you think about an exam that would be all performance tests, there's a little bit of a model with what Nevada has done during the pandemic, in that they increased the number, although I think they still have just 2 performance tests, but they weren't unable to use the MBE during the pandemic still are not using it. And so their exam is more weighted to the performance test. So there's a little bit of an example there. Other professions, I think, as Tracy mentioned earlier, architecture, for example, might be a place to look at for some examples of these work basket types of techniques. But I think there will hopefully be more examples and ideas coming out. And from a selfish perspective of somebody who just likes to see interesting new things in the world and a better profession, I think it would be wonderful if California worked on its own exam, because it would be a great place to generate additional creative ideas and so forth. I've always been a believer in multiple voices coming up with lots of new good ideas.
Emily?
Thank you. And just to comment on that last point, I think, this is true nationwide, but I have a heart for California. So I'll just say California has law school personnel serving as academic support professionals and professors that write their exams in a way that are really innovative and unique. And I think that there is a brain trust to be called upon, not to write the exam. We know the law school folks need to stay away from that, but to give ideas about how an exam question could be done, just as Dr. Merritt has. I mean, there's a lot of folks in our own backyard, I think, too, that could provide that. But Dr. Merritt, I wanted to ask one last question that I remembered. You had talked about the timing of the exam, and I think it was actually, just as it relates to not that speed is not the thing. And so I'm wondering, is it a goal for us, do you think, or, to create a universally designed exam as is sort of, if we think about the accessibility factors, we have, through the UC law schools, and there's 4 or 5 of them, the amount of students that need testing accommodations is now about 20% average, and that's going to increase. So in just thinking about how we design this from an accessibility standpoint, obviously, we've already talked about the length of the day, but in just thinking about how to design a test that is universally designed or takes into account accommodations that are typical now for some law students or applicants, how do you suggest we sort of go about thinking about those issues?
That's a great question. And I am a big fan of universal design. I've seen lots of ways in classrooms that I think it has improved education for everybody. It's another area in which, excuse me, I think we would need some pilot studies or research or field testing, because I don't know what the effect would be if we said, for example, I mean, in theory, it would, I think one could say, look, you're going to have a work basket of materials. There's going to be 10 problems that you're going to solve. And we think they'll take between half an hour to 2 hours, depending on each problem. You can do this in 2 days. You can spend the whole week on it. You can spend as long as you want on it. But I don't know what effect that has in terms of anxiety and stress for some people, whether it's actually beneficial or harmful. I've given law school exams in which I've given more time than I thought anybody would need. They've still had students who were accommodated who went in other rooms. And I've certainly had plenty of people leave early so that it seemed that they didn't all feel they had to be there for every last minute. But I think it's something that we should do more research on and figure out. Now, this is an area in which we may be able to borrow expertise from other fields, because it's a question that comes up on all these licensing exams. So Tracy and James, for example, may be able to tell you that, oh, we've already tried that in this other field, and we found that it really still makes sense to have accommodations, that we want to field test these questions, and it may be that the performance test should be 2 hours or an hour and 45 minutes instead of 90 minutes. But I would really look to their expertise on that. And on your first point that you made, that's a great point to make. There is a lot of expertise in law schools now. In fact, that study that LSAC did, where they found that the performance test closed this gap in grades. They had brought in, I think they had 3 or 4 legal writing professors who designed not only the performance test, but the rubrics that were used. So their thinking about how to design rubrics was extremely helpful.
Thank you. Yeah, our legal writing staff gives a performance test as part of their graded assignments every semester. So I know that there's a lot of folks that are doing that. Thank you.
I'm surprised that more law schools haven't incorporated the performance test in their classes. It may be because it's just, I don't know, the wrong length or something for incorporating. I've never done it, for example, in evidence, even though there's probably some that are evidence ones. My hope is that with these new format questions, that in fact a criminal law class would incorporate one of these questions, because it's a more really, you know, for the students to do partway through the semester, a more realistic introduction to criminal law.
Well, thank you, Dr. Merritt. The framework and the lenses in which we can look at these issues that you've given us are really helpful. And so we really appreciate your time again. I'm sure we will have additional questions in the future for you. So appreciate it.
Thank you. I will send Amy my slides later today, and I'm off to another meeting. I'm sure you have another speaker coming on.
Great, thank you. We're going to turn our attention to the CAPA recommendations specific to knowledge and the subjects to be tested. I think, Emily, you were going to spend a little time on review. This would probably be a good time to do that. I'd like to do that first, and then open up a discussion specific to the subjects that we believe should be on a future exam.
And Josh, right before we go to Emily, I want to just give a little bit of background on CAPA, just to remind everybody. So if that's okay, I'll start before Emily. Is that all right?
Yes.
Okay, so I just want to get everybody back on track on the purpose of CAPA and a little bit about the methodology before we dive into the recommendations. So, the State Bar pursued the CAPA to ensure that the exam content, and that includes the breadth, the depth and complexity, was related to the knowledge and skills required of entry-level attorneys. Also, to provide a documented link between the exam content and current legal practice, to provide a blueprint for the bar exam content and question development, something that we're relying on today, and also to inform the development of a definition for minimum competence. Next slide, please. And so just to remind everybody, the working group members included attorneys from most geographic regions of the state, those who work in private and public practice, attorneys in large and small firms, deans from the California law schools, 2 judges, a representative from the California State Legislature, and an out-of-state attorney who was previously chair of the board of the NCBE. And the working group itself, that was the chair of the State Bar Board of Trustees, was appointed to serve as the chair of that working group. We used grants funding from Access Lex to support that project, and Scantron was the consultant that helped us conduct that study. The working group it was formed in 2018, had an initial meeting in October of 2018. One of the first initial recommendations by Scantron is to set up a small subset of the CAPA working group, and they served as this practice analysis model. And that was created in January 2019. That practice analysis panel reflected the same diversity that I mentioned in the CAPA working group. And their charter was to develop the structure foundation of the CAPA survey. And so they did that by looking at areas and defining the areas of responsibility that we're going to look at. That is, what are the major responsibilities or duties that comprise the practice of law? By looking at task statements, that is, definitions as to what those areas of responsibility are, and the legal topics in the different areas of law. And those elements were used in the attorney data collection that happened through the fall of 2019. Next slide, please. So once the survey was developed, the working group agreed that the survey needed to capture a number of different pieces of information about the responsibility and legal topics. So they looked at the frequency in which these attorneys practice in specific areas and in the legal topic, using those legal topics, criticality of the proficiency in the task.
I'm sorry, Amy, 1 second. The slides haven't been advancing.
Oh, okay.
We can get those slides to the right place.
Okay. Are we there?
Yep, I think we're there now.
Okay, sorry. The criticality of the proficiency in that task and performance expectation, which is whether the performance of a particular task was expected of an entry-level attorney or was considered appropriate only to more experienced attorneys. There were 2 separate methodologies that were employed for the data collection. I just want to remind everybody, I know that this has been presented in the past, but I want to talk about the approach that CAPA took. There was a traditional survey that collected information by sending out a survey, and respondents had to recall whether those tasks and different legal domains had been, they had participated in the previous 12 months. We also used a alternative methodology, the experiential sampling methodology, and that required, it was a short web-based surveys that were delivered by email at random times during the day and throughout the workday. And attorneys, rather than recalling the previous 12 months, had to report on what they were working on at that moment. And so it took no more than 2 to 3 minutes to respond to each of those requests, and allowed also for attorneys to respond to multiple surveys throughout the day. And that aggregation of data collected from a large sample of attorneys created a statistically robust sample for us to rely on. Last thing I'll mention about the sampling design is that the response rate for the traditional survey was 8%. So we had 5,100 respondents in that category that responded in that traditional survey. And for the ESM survey, that was the response rate was 18%, so 11,090 respondents. So altogether for the ESM, because people could participate more than 1 time a day, so about 3 times a day, that yielded about 74,000 responses on what an attorney's daily activities were. Now, again, I mentioned the various items, and so all of that data, once it was collected, the CAPA group continued to work to synthesize the data in order to make the appropriate recommendations. So aside from recommendations on the skills and the topic areas, this is part of the overarching recommendations, the definition of what an entry-level attorney is, and that is the first 3 years of practice, and also the construct that would be that would lead to what the bar exam construct statement is, and that's something that we've adopted here in our BRC discussions, specifically that the California bar examination assesses legal knowledge, competency areas, and professional skills required for the entry-level practice of law and the effective ethical representation of clients. So I just want to highlight that how we got here, how CAPA developed these, and then developed its recommendation and the data that it relied on. And with that, I will now hand it over to Emily.
Great. Thanks so much, Amy. That was a great summary. Really appreciate that. Can we advance the slide? Thank you. So I'm going to just talk briefly about the 8 legal topics, sort of the knowledge, quote unquote, knowledge side of CAPA recommendations. And then Dean Jackie Gardina, who's also on CAPA, is going to be talking more about the skills piece. When we looked at the data and both sets of data, both sets of survey, we looked at the frequency and sort of other factors, I guess, including what we as the CAPA working group, we're looking at, how do we ensure that we are still testing foundational knowledge for every entry level attorney. And I think this is one of the things that the NCBE did as well. You can see our 8 legal topics are up here. When I talked about this at a prior meeting, I discussed the fact that the NCBE recommendations for their 8 legal topics mirror ours, except for administrative law and procedure. They do not have that. They have business associations instead. But we did arrive at the same 7 other topics. I'm certainly happy to address questions as it relates to why did we add some, why did we remove, but it is in the CAPA report as to why some were selected and some were not. I want to just key in again on professional responsibility. We all know that we want to make sure that we have ethical attorneys that are entering the profession. The bar exam, I think, is ill-equipped to determine that, but we do have several touch points for at least a applicant understanding and knowing and demonstrating knowledge about the professional rules of attorney conduct. And so we have the MPRE, we have in the new attorney training program, there are requirements there, and there's the MCLE requirements for ethics, in addition to the moral character application that comes alongside the bar exam. So, certainly that we're not saying that we're minimizing professional responsibility, but just as it relates to the scope of the new bar exam, we felt that that was one that could be tested elsewhere and determined elsewhere. Administrative law and procedure is one that we looked at primarily. It was based on both sets of survey responses, really rated what our attorneys are doing and what our attorneys believe are important in California. Really includes a lot of the administrative law, both in terms of sort of the law that governs and limits agencies, but also the laws that agencies make themselves. And so that was felt to be a topic that we definitely needed to include. So we also eliminated a few other, or suggested to eliminate, community property remedies, trusts, wills and succession, and business associations. And again, the CAPA report kind of indicates why. The business associations, there are a lot of entry-level attorneys that work for business law firms, but a lot of that work is more specialized. And the other categories, there was a lower composite score for those subject matters than the other topics that we put on the 8 legal topics list. And again, part of our goal in the CAPA report was to really make sure that, in thinking about what knowledge should be tested, we could obviously test, 25 different subjects, but we felt that we wanted to make sure that we were testing fewer subjects to allow for an exam that would also test skills. So if there's any questions, I'm happy to answer, but I will turn it back to either Amy or to Jackie.
I'm happy to go next, Amy, unless you had another thought.
It's to you, Jackie.
Amy, is it possible that we can have just a conversation about this? I'd like to try to break before we get to skills and see if there's any comments or questions. Maybe Emily would be helpful just to address the thought process around adding administrative law and procedure.
Sure. So the composite score for administrative law and procedure was definitely within the range of the 8 legal topics that came up, and where it was higher than some of the ones on the list. And when we look at that, again, we're finding a lot more administrative law in California, and a lot of attorneys doing that, regardless of whether or not they go on to do litigation or transactional work. A lot of the work that they're doing starts at the administrative level. California is a very heavily administrative state. And so again, I think that the substantive law and the procedural law of administrative law is something that a lot of our attorneys are seeing. So that, and again, the composite score sort of bore that out.
And one last question, and then I'm going to go to questions. When you say 8, did you come, I can't remember from the CAPA and the review, did you come at it with the desire to find 8, or you said these are the 8 most important? What is the relevance of 8?
Yeah, I have to remember, but we did not come up with, we want 8. We could have kept all of them, but we did decide that we wanted to reduce the topics. And when we looked at the composite scores, again, from the 2 different surveys, there was a clear break with some of the ones that we removed. Again, real property and I think constitutional law were ones that had lower composite scores, but they were foundational and core knowledge, and we felt that they really still needed an entry-level lawyer still needed to have general knowledge about those 2 subject areas. So those were moved to the top. So 8, no magic number, but that's where we ended up.
Okay, great. Alex?
Yeah, Emily, I got a questions for you, and thank you for explaining some of these statistics. I only have a question about, for example, constitutional law. If you look at page 14, constitutional law clearly, I think has a composite score of 9.6, followed by estate planning 8.4, and then real property 7.4. And I do believe somewhere below you explain why the CAPA study group decided to go with real property and not estate planning and trust. And right now I'm just reading off of why it was excluded. And I would just quote directly from the study on page 17. It says, based on the lower composite scores and the fact that concepts within remedies and trust and wills frequently blend with contracts, torts, and other legal topics, the working group determined these topics could be removed from testing. So it sounds like, based on this explanation, that the reason why the CAPA study group decided to remove remedies and wills and trusts is because it is, at least the groups believe that the subject matter is already incorporated in the contracts, torts, and legal topics, and therefore, the recommendation is to remove them entirely. And did I get that understanding right? Or is it that, that we should just do away with remedies and trust and wills? Because that seems to be 2 different positions to me. One, you're saying, the study is saying, well, it's really blended with other topics, and so we don't need to be redundant here. At the same time, we're saying we should remove those topics because it's not, it doesn't have a good or high composite score. So can you please clarify that for me, please?
Yeah, I can do my best. And I know Judge Reiser and Jackie Gardina are also members of CAPA and can talk about this. But I think, the composite score was sort of our first level of look at these things. And when we saw that those had lower composite scores, we did ask, because we weren't just going to go by score. I mean, we were here as a group to add a humanity to this process and an understanding that numbers can't tell us, under the watchful eye of Ron P. and Dr. Henderson for sure. But I think with remedies, it did have a lower composite score, and it does test a lot of things that one finds in contracts, torts, and some of property. I think trusts and estates had a lower composite score, and it's also something that we really did sort of look at what would we consider to be somewhat specialized rather than broad-based foundational knowledge. And trusts and estates and family law, those were ones that we felt were very important bodies of law, but also specialized, that maybe an entry lawyer would not be required to know the ins and outs of developing a trust or an estate, rather having general knowledge about when a client comes in and says, I want to do X, Y, and Z with my estate, sort of where to go with that. And maybe some client counseling could be a skill, but not necessarily all of the knowledge and all of the technical rules that one would need to know for that. So that was sort of the discussion we had. The first layer, again, is the composite score. The second is thinking about what is specialized, what isn't, and what is foundational knowledge.
Am I right? The first, I'm gonna look at the composite score. I want to make sure all the members understand the differences between the scores. Clearly, there's a composite score, but then next to it, there's a critical score and a frequency score, right? Am I right? The frequency score is about the frequency in which the surveyor believe that they practice that specific legal topic in terms of frequency, and then criticality is how harmful in connection with that topic. If somehow.
Yes. Yes, and I think Dr. Henderson could probably speak to that better than I, but that's my understanding.
Okay. Yeah, it's the first score. Again, I'm just looking at this chart, only numbers. That it sounds like the estate planning has double digits, meaning there are a lot more people thinking that this is a frequently used area, but somehow we are discounting that and chose con law, for example, that has far lower by a magnitude of 4, right? Where the frequency, con law is 6.1, we chose that, but then estate planning that has a double-digit score and we discounted it. So I just want to make sure I understand what the mental process was by the Kappa group, or whether this is mostly subjective. I understand there was a lot of discussions, and whether those discussions was based on empirical data or just based on some study that we're just not aware of.
So
okay, well, hopefully I've answered that, but Dr. Henderson, go ahead.
Yeah, I just want to say that the point of departure in the discussions were survey data and the findings that are presented in the tables in this report. When this information was given to the working group, it was along with the advice that accepting the numbers blindly without exercising judgment would abdicate their responsibility and the trust that the court had and the bar had in appointing them to the group. That it was important for them to bring to the discussion their own understanding of how these different topics interplay, and marry that up with the data. The data were the starting point, and the data were all, and not just a starting point, they were considered and debated all the way through. I don't want you to think that the numbers say one thing and the judgment of the working group says something entirely different. It's an amalgamation of the information provided.
Thank you.
Judge Reiser. Oh, you're on mute.
So I sat on the Kappa group, and the answer to Alex's questions are complicated because we have to contextualize what the Kappa group was doing, right? We weren't trying to create a paradigm for a new bar exam, but while there was not antipathy towards certain legal disciplines, because, for example, all I do is trust, big trust, right? Every single day of my life, I do trust. And one of the ultimate recommendations of the committee was not to test for wills and trusts, which, was a sort of a mixed bag to me. But the goal of the committee did have some antipathy towards memorization, right? So the thought was, why are people having to memorize a bazillion topics when really it's about how lawyers think and how they react to certain problems, issues, and situations that should be the hypercritical mass of the bar exam. So the thought was to simplify the number of topics so that legal thinking and analytics could take precedence over sheer memorization. So that was partly the focus. And so when the committee began, there was a lot of talk about what topics should be considered as part of the bar exam. And there was a national list that was utilized. And for example, I pushed to have employment law and IP as part of what Californians do. Employment law actually wound up on that list, and a boatload of lawyers, perhaps more than any other specific discipline, were doing employment law in California. So I think that to a large degree was a catalyst for the administrative law and procedure because of the FEHA overlay with employment law. But having said that, the idea was to define those things that people are actually doing. And then there was some subjective analysis, as Alex suggests. So yes, not that many lawyers are practicing constitutional law in California, but the subjective analytic was you can't not have constitutional law on the bar exam because it's too fundamental to what we do, who we are, and the tradition of being a lawyer. So there was some give and take and push and shove. So ultimately, because the committee wanted to reduce the topics that needed to be memorized for the bar exam, the recommendation was to remove community property, wills and trusts, both of which, in my own mind, are rationalized as legal specialization topics. So to the extent someone just said, hey, I don't need to take family law or community property in law school because it's not going to be on the bar exam. If a Californian wants to get legal advice from someone who practices in that area, they can look to legal specialization. Same with wills, trusts, and succession. Remedies is cross-disciplinary, as we know. Business association was a little more controversial, but in the final analysis, I think we have to consider what the purpose of the CAPA group was, and the idea was to focus more on what lawyers do and how we analyze things, and less upon this vast encyclopedia of topics.
Tracy?
Yes, I was not on this working group, but I wanted to just share that this is, again, typically how we do our examination outlines at Consumer Affairs. It's a mix of taking your data and some input from your subject matter experts. So just as Dr. Henderson outlined, his role is to kind of help guide the group to make sure they don't forget the data or exclude the data, but to talk through the data and come to a consensus, because when you get a group of licensees together, subject matter experts, of course, they want everybody to know everything. It's a test. We want them to know all the details, but really you've got to pare it down to what's reasonable for entry level at this particular point in time, which I think it's great to get it down to 8 topics. You can delve into those more deeply, and then those others become specialty areas. But a gentle reminder is that our guidelines say that we look at professions about every 3 to 7 years, around that magic number of 5. So while these may be the topics going forward in time, it could change, or again, the number of questions within the topic. So I think it's important to keep it in mind that this is the snapshot in time of what this group and the data shows, but potentially it could evolve where one of these falls out and perhaps another one comes in 10 years from now. Thank you.
Any additional questions? Amy, I want to take a minute and make sure that we all understand where we are and what we're trying to get accomplished here. It's my understanding that the Board of Trustees and the court is asking us among other things, for a recommendation around the subjects and subject matters referred to as knowledge in CAPA, and that we're being asked whether or not we would agree with the CAPA recommendations of these 8 legal topics, or whether or not we think there are additional or changes that should be made as part of those recommendations. Is that a fair assessment of what we're being asked and where we are?
Yes, correct.
Okay, I can tell you personally, I'm struggling with, and I have a suspicion that the people that were on CAPA are just going to smile when I say this, but I'm struggling with the administrative law and procedure addition and reasoning around it, and the subtraction of business association. The difference between the two is hard for me to understand. Maybe we can address that and the thought process that CAPA had. They both seem like legal specializations to some degree. I'm not, and I know that the goal was to, at the time of CAPA, and I think this group shares that goal. I don't want to speak for everyone, but the need to limit memorization and limit the number of topics to those that we find to be the most important. So I'm going to turn to Kristen and then maybe someone from CAPA.
Josh.
Yeah.
Josh, before we go there, I do want to talk, I'm just going to pull out, statements from the report itself, like just about how administrative law and procedure got on this list altogether. And so the idea is that the topic met the threshold composite score, but aside from that, it covers a broad and diverse area of practice, encompassing procedures and regulations in the professional licensing, unemployment insurance benefits, Social Security and retirement benefits, discrimination, labor and employment, workers' compensation, immigration appeals, securities, zoning, and many other regulatory issues. Administrative law and procedure also defines the scope of judicial review and establishes uniformity in the rulemaking process. So given those characteristics, the working group agreed that administrative law and procedure is a topic that with both foundational and practical, it's both foundational and practical, and that it should be tested on the bar exam. So I just want to give you a little bit of the background as to how that ended up here.
That's a smorgasbord of issues thrown into one title. Thank you for the background.
Sure.
Sorry, Amy, I should have mentioned that. I apologize.
Kristen, you have a question?
No, I was actually just going to say a little bit about what Amy just said in support of that. And as somebody who's done administrative law for 26 years, both rulemaking, litigation, and as a judge for the last 14, I know for a fact that most people who end up in court end up in an administrative tribunal of some kind, and those practice areas are really important. They are often areas in which people are unrepresented because they can't find sufficient attorneys with knowledge in this area. And so, although I wasn't on the CAPA working group, I was thrilled to see administrative law and procedure on there, just because I do think it touches areas that impact both on a state and federal level, so many Californians that I think it ought to be there. So, and I'm biased since that's what I've done for years.
Thank you. Alex?
Yeah, so I pulled this traditional survey presentation from the State Bar website that was published on October 3rd of 2019 by the CAPA working group. And this presentation encompasses the survey results of all the practicing attorneys in California. And it basically polls them as to, what practice they're specialized in and how often they practice in a specific area. And I note that other than civil procedure and contracts, there are more people, attorneys, practicing business associations than any other topics that are listed on this slide. And so I wonder, I have to think to myself, why are we taking out business association when you have more people practicing in that specific area, and specifically in California, where commercial business transactions are so vital to businesses, that somehow we decided is not a topic of interest. That bothers me a lot. And yet, on the other hand, and this is by no means diminishing the importance of administrative law and procedure, I certainly think that at the minimum, for the sake of California, that we should at least consider adding business associations to the list of topics and not to exclude it. So that's sort of where I stand in terms of just looking at how many people actually practice. And I can't fathom for the life of me why we're taking it out when there's so many people from first year to 2 to 3rd and 4 to 5th and 6 to 10 and more than 10 years, that year of experience group, that there are so many more people practicing in business association than any other fields, of course, other than CIFRA and CONLAW. So that's sort of my take. It's free for all.
Emily?
I just wanted to comment on the composite ratings. Business Association rated really low. And so we did have a really robust discussion about, even though it rates low, obviously what Alex said is right. There's a lot of people that, especially at the entry level, that are doing this work. But we did feel that there was a lot of crossover too with people that might categorize business associations, but they're actually doing a property deal, for example, or they're doing, something related to employment law. So there was, if people are just thinking about doing business associations and testing on agency and partnership and LLC formation and things like that, that is a little bit more, if you look at sort of the outline of business associations and even on the NCBE, it is testing a little bit more business formation than I would say maybe doing the actual practice of a business law practice. Now, that's not to say that has to be that way, but when we looked at the composite scores and had those conversations, those were some of the things that we brought up.
Alex, your hand's still up. You have another question?
Oh, I'm so sorry. No, I do not.
Okay. We find ourselves at a point where we could go 2 different directions here. The first one would be if someone wanted to actually take an action and recommend or introduce a motion specific to topics around a recommendation, then it would be appropriate at this time. Or we could move to skills specifically and then come back to knowledge and skills or subject matter and skills at the same time. Any thoughts from members? If not, we're going to move to skills. Okay, Jackie, are you ready to talk about the CAPA recommendations and the skills portion?
I am, and I think we probably need to advance to the next slide. So these should look familiar to you because Debbie Merritt included these on her slide as well. And so I want to go back to what we were talking about in relation to the knowledge, which is the scale that was used, because I think that's really important in understanding the composite score. And I want to make sure people understand there was frequency, criticality, and performance expectation. Frequency was on average, how frequently did you perform this work or activity during the day? Criticality was what degree of harm may result if you're not proficient in performing the task or proficient in the competency. And then the performance expectations is when in your career, first year, first 6 months, first year, beyond that, were you required to really perform these competencies? And all 3 of those were important to our understanding of both the knowledge and skill basis, since what we were asking is minimum competence for entry-level attorneys, which was focused on the first 3 years of practice. And so the composite score comes from primarily that criticality and frequency piece. So when you look at this list of 6 competencies and professional skills, Those are the ones that had the 6 top composite scores in both frequency, criticality, and then their composite score was 10 or above. I think it's important to note, for those of you who haven't looked at it on page, let's see if I can get it, the criticality measurement that was done, it was fascinating and actually a little frightening to see that for many new attorneys, they don't understand the potential harm to the client until their 4th year of practice. So you see the criticality measure kind of go up dramatically for those who have been in practice for 4 or more years, which to me spoke a little bit to that we want to measure what we value, and we certainly value protecting our clients and protecting the public. So really emphasizing that these particular competencies and professional skills are critical to their protection of the public was, I think, a real eye-opener for me to understand about those entry-level attorneys. So each of these are broad categories, but if you look to Appendix C of the CAPA report, which you can find online if you don't have it available to you right now, you'll find that each of these actually have very specific sub tasks embedded under them. For example, under research and investigation, we have 10 different tasks that could be tested under that. Everything from determining the governing laws to preparing internal working analysis of the case or matter. Likewise, for issue spotting and fact gathering, there's 7 different tasks beneath that. And drafting and writing, we have 9 different tasks. So when we're talking about the potential skills, these are the broad categories. Within these categories, there are then specific skills that are defined underneath them. And each of these skills or competencies were chosen specifically because of that composite score at 10 or above, which was a combination of the frequency used as well as the criticality of that competency or skill. So I'm guessing that this might be less controversial than the legal topic one, but I welcome any questions that I might be able to answer.
Jackie, I don't see any at this time. I have a very brief question. Were there, and again, I've reviewed it in the past and don't remember offhand, are there any competencies or professional skills that were debated and not included? I mean, I know there were some, but any that were close to being included and reasons why we ended up with these 6?
Yeah, well, so it's a great question. And if you look at the composite scores, we drop off a bit after 10. I think maintaining client relationships and negotiation and closing. And as you saw, Debbie recommended that we actually include negotiation in our list, given both what lawyers need to do on behalf of their client, but also on behalf of themselves as well within the workplace. But I think some of these were perhaps, it might be challenging to test. For example, practice management skills or supervision and collaboration skills, not impossible, but more challenging. We also chose a composite score, recognizing that we couldn't test for everything. We chose a composite score as a cutoff, and there wasn't a lot of debate about what fell underneath that score, but I would welcome the closest ones were maintaining client relationships. Again, not impossible, but perhaps challenging to test. And then the negotiation and closing was the next step.
Thank you. Susan?
Just to follow up on the question you just asked, Josh, I wonder if any of the members of CAPA would care to comment on Professor Merritt's suggestion that we add negotiation and how you feel about that.
I'd like to comment on it. I mean, as a professional neutral, right? The ability to resolve cases is becoming an increasing need because of resource limitations in the courts. And so it is a skill set, ironically, that younger lawyers seem to have more than the more senior attorneys. And I don't know why that is the case, except because perhaps how they're being taught in law school, or just an appreciation of the fact that clients are often better off getting their issues resolved rather than litigating through the state Supreme Court. So I mean, it's what I do for a living, but I think it is the future of litigation, because there's no way our judicial system can withstand the number of cases given the limit on resources.
Karen, I think you're next.
Thank you. And I think Judge Reiser, you immediately went where I was going, which is I would strongly encourage us to include negotiations, and it ties in with my, I guess, one substantive question about the topics is remedies seems to be actually a fairly essential, and I don't know if that's intended to be, woven into some of the other topics, but when as I consider the practice of law and then the administration of disputes and rights, it's going to end up, as Judge Reiser describes, in negotiated settlements over, entitled remedies. So it seems to me that whole subject ought to be something that we incorporate, whether it's as a subsidiary to some other topic or skill set or its own, but I wouldn't want us to neglect that.
And I'm happy to speak to some of that as well. So going to the first question about negotiation, and then I think, Karen, it incorporates the remedies piece as well. When CAPA was making determinations about what to include or what to exclude, as Dr. Henderson pointed out, and as others did as well, it was both data-driven and policy-driven. So when we're asking the question, should we include negotiation? If we look at the data, it has a composite score of 8.4, which would suggest that it's fairly high up compared to some others. Then it becomes a policy decision for us to make about whether or not we think for California it's essential or important enough that a new attorney establish minimum competence in negotiation in order to become licensed. And so I just bring the same analysis to the questions about remedies or business associations, because they are conversations that we had on CAPA, starting with the data, the composite score, understanding what that means, and then asking as a policy measure, is it important despite the data that someone be able to establish minimum competence to get a license? And so when we're talking about business associations or remedies, look at the composite score and then ask the question whether or not, as a matter of policy, not does every attorney in California need to know or understand remedies or be able to negotiate, et cetera, during the course of their career, but does an entry-level attorney need to establish knowledge of business associations or competency in negotiation in order to get a license? Is it essential to the protection of public? And so that's how CAPA went around choosing the particular knowledge realms as well as skill realms.
Emily?
So I just want to comment on the negotiation. I think for me, when we were talking about negotiation on the CAPA working group, the category was negotiation and close. So how are you closing either a deal or a case or something like that? I think the broader, if you look at the NCB outline, the broader context that they have is negotiation and dispute resolution, which is a broader topic, I think, than what we necessarily asked and got composite score for CAPA. So I'm sort of agnostic as it relates to whether or not we include that. But to Judge Reiser's point, I do think that we need to be teaching our new lawyers negotiation and alternative dispute resolution, and whether or not it's, we like it or not, if it's on the bar, it's going to be taught. I will say that, in just reading the NCBE's sort of subject matter outline about it, their first thing they talk about is in a client matter, one of the things that they would have to do is identify which claims to recommend bringing, which remedies to recommend seeking, which evidence to present, which arguments to make, and how to respond to arguments. And then, also look at clients' objectives, and all of that, could be done with some sort of subject matter around it. And then obviously looking at what resolutions could come from that, and what are the disputed issues, et cetera. So I think, you could put that in skills, you could put that, you could add that in. The other thing I wanted to just mention is litigation is a separate one that we have that the NCBE does not have. And I think there's room in there for determining kind of what that underlying outline might look like, and might include some things related to negotiation. So I don't want to mix too much, but I would just say from the CAPA, if we decided to add negotiation, I would want to add negotiation and dispute resolution, not negotiation and close, the way it was sort of designed at CAPA. But that is, anyway, I'll leave it there.
Alex, you're next.
Yeah, I was part of the NCBE's test design group, and I can confirm that these domain areas are consistent with what NCBE has found to be critical, with the exception that NCBE also included negotiation and dispute resolution as a key area. In fact, NCBE weighted that domain just as important as client counseling, and even more important than client relationship. That is not to say that it is important, but I just wanted to throw that extra data point out there just for your consideration. But aside from that, my personal opinion would be negotiation and dispute resolution is cross-discipline. Regardless of whether you're a transactional lawyer or a trial attorney, negotiation and dispute resolution will come into play at some point of your career. Either you're trying to settle out a case or come to some kind of a compromise with respect to a provision on a contract. You're going to have to understand and know how to negotiate and resolve a dispute. On that basis, I don't think this is something that can be just simply discounted, whether based on a policy reason or empirical data. But this is something that really needs to be considered and debated and decided whether this is something that we need to include.
Tracy?
So I am not a practicing attorney, but the data would tell me that this is not minimum competence from the discussion. And then as a psychometrician, it may be challenging to assess. I see this as sort of like supervise. We get a lot of supervise such and such in our content outlines, as a task statement. And we tend to remind our subject matter experts that it's more of a personality construct, and we take them back to the actual content that they're supervising, or in this case, what is being negotiated. So going back to earlier points, is negotiation embedded in these competencies? And is there a way to capture that when you actually develop your questions within these areas, whether it is the earlier legal topics or these skill competencies? Could you measure negotiation associated with that? And again, that's more of a question for the group. Thank you.
Tracy, I think I'm hearing from folks that yes, it's embedded in some of the other areas, but with negotiation and dispute resolution, I think Judge Reiser pointed on it earlier, the resources, we're obviously quite a litigious group here in California, and the resources that go into litigation have slowed down our processes. And I think that it was more of a policy statement that we're discussing whether or not we would, as a group, believe that new attorneys would benefit from understanding and considering all of the alternative dispute resolutions immediately upon practice. So that's how I see it, at least the conversation.
Okay, so you would call it out and it would have its own weight or priority or emphasis, is what it sounds like the group is considering.
I think if the group decided that it was of that importance, and it would be a more, and I do understand the difference that has been delineated between negotiation and closing, which I don't think would be as relevant as negotiation and alternative dispute resolution, which is what's being discussed. Alex, you have your hand up. Can I go to Dr. Henderson first? Do you mind? All right, Dr. Henderson.
Thank you. I just want to take us back to the basic logic of what practice analysis is, and picking up on what Dr. Montez talked about a little while ago around a snapshot in time. And it is the consensus of opinion collected from the field and synthesized by the working group. I just want to point out that there was consensus in the data, and the working group was intimately familiar with the data, having met monthly for 18 months and read reports in the meantime between meetings. It's not that I'm opposed to making a change in this, but I want to preserve the consensus that demonstrated in the data and that resulted from the working group's deliberations. My concern is that by making a change here, then we open the door to making other changes that might eventually undo the integrity of the intense process that the State Bar followed through the practice analysis. So it's just a warning, and that's it. Thanks.
Yeah, Dr. Henderson, I mean, I appreciate the warning, but I do think that we have a specific charter that's been given to us in addition, which is to look at it and to make recommendations. And so I don't want people to feel like we're a rubber stamp of what's already been done. I think it's great information, and the majority of it, I understand the time and effort and thought process that went into it. We are not that long, but a couple of years later with a lot of changes that have occurred in the world. And the question is, do we hold steady to all of them, or is there some addition or subtraction that we think would improve it?
Absolutely. It's the charge of this group, and I get that all together. I just want us to be smart as we make these, as we undertake this consideration and make the judgments that we'll make.
Jeremy?
Yes, thank you, everybody. I just want to highlight, and sorry, I'm in a coffee shop because of the back of the teams. So I just wanted to just highlight that I agree with what's been said about the negotiation and dispute resolution. I think it's an often overlooked thing, particularly in law school. It's mostly done as an extra class, as a not as a required course. So I just wanted to highlight how important that is to have that as an aspect in the opinion. That's all. Thank you very much.
Mylin?
I was just about to lower my hand in response to Dr. Henderson's, I won't call it a rebuttal. I think I better just I'm very torn here, but I do think I want to go on record as saying that I see negotiations as high in criticality, not well enough captured in the other skills that are identified. And I so respect the CAPA working group process. So I do feel torn, but as I work with law students who are making that transition to lawyers, I do see them really struggling with this skill. And so my inclination at this point is to add it, but I do hear the concerns that Jackie and Dr. Henderson have expressed, and I really appreciate the deep thought and research that went into CAPA's work.
Thanks, everybody. Amy, I think, can we take the presentation down for one moment? Thanks. It's much easier to see everybody. Amy, I think it would probably behoove us, we've been at it 2.5 hours, to take a quick break, let folks get some lunch, come back in 15 or 20 minutes and discuss where we are as a group as far as what subjects and what skills we want to add in the recommendation. And I do understand that in addition to that, we've been asked to discuss what percentages we think would be appropriate in a subject matter versus skills on an exam. So I'd like to take that up, and then we right after the break, and then we can move on to our next order of business. Does that work?
Yes, that works, Josh. So yes, it's about 12:35. So are you suggesting a 15 or 20-minute?
Yeah, as much as I wanted longer, I think 15. Why don't we come back at 12:50 if that works, and then we can keep soldiering on.
All right, will do.
Okay, thank you, everybody. All right, folks, we're gonna let people join us again. We're gonna start up in a little under a minute. All right, let's get started. We're starting with Tracy's hand up. Is that purposeful, Tracy? All right, so sounds like you have something to start with. Tracy, go ahead.
I'm happy to make a motion on the legal topics if that would help move things forward. You ready?
Yeah, I am. I think that would be great. Amy, is that something that you can help with?
Yes, Audrey will be helping us on that effort.
So I have some draft language, but I will start from Tracy's motion.
Tracy, go ahead.
Your draft language that we see.
You want to read it? And then...
Yes, in pursuing the use of a California specific exam reflecting California recommendations, it is recommended that the following 8 legal topics be adopted for a new bar exam: content outlined, administrative law and procedure, civil procedure, constitutional law, contracts, criminal and procedure, evidence, real property, and torts. And I'm stopping at that.
Yes, please.
I'll second.
Any other comments on the motion? I'd like to have a discussion if there is any. If not, we can move to a vote.
Yeah, Chair, I got a question for you. Just procedurally, do we need to vote on this motion today, or can it be tabled to another week? And the reason I'm asking is because I represent the committee bar examiners, and the committee chair has expressed to me that they would like to have a fulsome, more wholesome discussion on this issue before deciding how to vote on this motion.
Amy, do you want to address that?
So Alex, the idea, excuse me, is as a representative of the CBE on the Blue Ribbon Commission is for you to bring, both share and bring thoughts back from the CBE. So your proposal to postpone, is it to postpone a vote altogether on all of these items? Because that's what we're trying to accomplish here today. So in the alternative, what about bringing back this information to the CBE?
I think the idea is to table this until the next meeting, just so that I have a chance to receive comments and feedback from the committee of bar examiners. This is not to say that this issue is not important. It is very important for the mission of this full commission. I just want to make sure that we're not making a hasty decision on voting with just a few hours of debating. I certainly believe that each member deserves more time to sleep on the discussion that we talked about today, and also for all the stakeholders to think about these topics. My only concern is if we were to vote on this and then we receive negative feedback from other stakeholders, that we're not really achieving the very purpose for which we're striving to accomplish.
Okay. Any thoughts on this from other members of the BRC?
Yeah, Tracy.
I'm concerned about that because these recommendations are based on a very sound methodological approach. And if you consider everyone that was involved in the CAPA practice analysis and then the thoughtfulness and analysis of the working group, I'm concerned about not moving forward. I feel like we have a very strong, reliable and valid and legally defensible, if I may say, data and to move forward.
Natalie, you have comments?
Yeah, I, in addition to what she just shared, what Tracy shared, I also think that we, both us as a group as well as the public, knew that this is what we were going to be discussing in today's meeting and encouraged to start moving forward. So I think we're ready to move forward and start making some recommendations.
And I do want to highlight, sorry, in response to that too, is that we did bring some of this to the CBE. We specified what we would be discussing at this upcoming meeting because at the time we met in March. And so, you know, I just want to share that as a background. So it sounds like the consensus appears to be that we move forward with the vote.
Yeah, Amy, I'm inclined to move forward. I want to address again Tracy's comments. I like Dr. Henderson's earlier. I do appreciate them, and I think that we are taking that into consideration very seriously how much time and effort went into this. The CAPA study was something that was results were delivered to the Board of Trustees. The California Bar had never been part of a recommendation to the Supreme Court. I think our goal here is to take the best of what's there, which may be everything, have a conversation around pieces that we may or may not think could be additions, and move forward. Alex, I think what we'll do is it would be great if you could, assuming that we have a motion that moves forward, if you could report back to us at our next meeting. If there are additional comments, thoughts, questions from CBE, we'd love to hear them. But I'm concerned about timing. We have a goal here from the court to get through a lot of items in our next few meetings and get recommendations to them before the end of this year. And unless we keep moving, that's going to be hard to do. So I'm inclined to move forward with that. Are there any other comments, thoughts, suggestions around this motion? Or if not, I don't remember if we had a second.
We did. I believe Jeremy seconded Tracy's motion.
I did.
Okay.
All right, then with that, I'll start the roll call. Susan Bakshian,
Yes.
David Boyd,
Yes.
Alex Chan,
No.
Charles Dugan, Jeremy Evans,
Yes.
Jackie Gardina,
Yes.
Brian Harrison, Dr. Henderson,
Yes.
Tracy Montez,
Yes.
Judge Reiser,
Yes.
Natalie Rodriguez,
Yes.
Kristen Rosie,
Yes.
Emily Scivoletto,
Yes.
Karen Silverman,
Yes.
Mylyn Spencer.
Yes.
All right, the motion passes.
Oh, Amy, this is Esther, and I showed up an hour late, but I've been here, so, and my vote would have been no.
Okay, all right, sure. Motion passes.
Thank you, Amy. Okay, let's move to the second subject that we were talking about, which was the skills to be tested. If we're in the same position, is there any additional discussion, or does someone want to make a motion based on the discussion we already had?
Again, what I'm showing is this draft language ready to be amended.
I would appreciate if someone, maybe a member of CAPA who has the knowledge, would consider making a motion. That could be a good starting point for us and enter into a conversation.
I'll make the motion as written. It is further recommended that CAPA's recommendations on skills are incorporated in the new exam, drafting and writing, research and investigation, issue spotting and fact gathering, counsel advice, litigation, and communication and client relationship.
Thank you, Jackie. Is there a second or additional conversation dialogue around it?
I'll second Josh.
Second.
Chairman.
Oh,
go ahead.
This is Karen. I really, what are we doing with the asterisk?
That's my own note based on the conversation, and I just didn't want to lose it.
I would move that we clarify that those skills are included or incorporated within the topics.
So that would be a friendly amendment that you're asking Jackie to incorporate.
Correct.
I'm happy to take the friendly amendment. I do have a question for Dr. Henderson that I'd like clarification, but that might be better during the discussion period.
I think it's probably appropriate now. I think people are trying to make a decision. So let's move forward with your question, please.
Okay, thank you. So Dr. Henderson, the question I had is, we don't have any data on this. And so I am conscious of using both data and policy. I think everyone on a gut level believes this is important and necessary. But what are your thoughts about that our survey didn't explicitly speak to this particular skill for new attorneys?
So I think that the negotiation covered these 2 points in different places in different ways. And it's not that there is an absence of data to bring them in. I think that it is a valuable, I think it is valuable to be cautious at this point, but I don't think that this change alone would be fatal to the defensibility of the practice analysis overall.
Okay, thank you, Dr. Henderson. I accept the friendly amendment.
Can someone restate the friendly amendment for me then?
I believe, and Karen, you can correct me if I'm wrong, that we would add after communication and client relationship and negotiation and dispute resolution to the skills list.
And I guess just to clarify further, I don't know how this group feels about whether we want to add it as an and or as a sort of including, right? It could be a lesser part of, I think, client relationships litigation. It fits in with it could either be a nesting concept or an added concept. I'm comfortable either way, so long as we clarify that it's within the recommendation expressly. And defer to the CAPA team as to how best then to convey that.
Jackie, do you have any thoughts on, or I'll call on Emily?
I'm happy as the friendly amendment works to just to have it say including and then allowing people to kind of respond to including negotiation dispute resolution. Thank you, Karen.
Thank you.
Emily?
I would go and the reason is I'm not wedded to it, but if you look at the CAPA appendix and you look at under kind of where these are parsed out, it's a category called resolutions, and there's counsel and advice, which we have, and litigation, which we have, and then the 2 other categories are negotiation and closing and alternative dispute resolution. So I think we did sort of capture some of that in what we were discussing, although not explicitly, because I think we didn't do a lot of talking about it because the score was low. But I would, I think it's distinct from, based on that, I think it's distinct from litigation and distinct from counsel and advice. And so I would use what the CAPA report appendix has as it relates to the subtopics within negotiation and alternative and dispute resolution. So anyway, it's a long way of saying I would keep the and.
Dr. Henderson?
My preference is for it to say including, and the reason for that is that the discussion around those abilities already being addressed in some of the other areas that are on skill areas that are on the list. And I think that it preserves more firmly the basis of the study and data and the debates of the working group.
Emily, will you accept the including? We could take 2 votes, but I don't think that's going to be a good use of our time.
No, I'm happy to do that. I will just say that in our recommendation that is more than this vote, I just want to ensure that we include that when we say including negotiation dispute resolution, does that actually modify every other piece on this list? Like within drafting and writing, we're not necessarily recommending that all drafting and writing needs to have negotiation and dispute resolution involved in it. So that's why I wanted to have it be separate. But I get why, from Dr. Henderson's point of view, it's better to have including. So long way of saying I'm fine with whatever the chair would like.
And again, for reference, these motions are going to be the basis of the recommendations that we will ultimately make. And I think that the message that I'm hearing from this group, this body, is that it's important that when the future exam is formed and considered, that negotiation dispute resolution is considered as part of this one of the subjects that will be tested. I think it works with either. Jeremy? I'm going to keep moving.
Yes. No, Josh, sorry. I was trying to put the mute button. I was just going to say I agree with Emily's initial thought, was that I think and is better, but obviously defer to this group. But yeah, that would be my preference.
Judge Reiser?
Right. So, I mean, my preference is and, but it's the problem with the way it's written is it looks like including relates to communication and client relationship. So it's awkward, just semantically.
Okay. I mean, it appears to me that based on the comments, we have more people that are comfortable with and. So if that's the friendly amendment and a second to that, then let's go ahead and take a vote with and we'll see where we go. Audrey, is there any more procedure that we need to, before a vote, consider?
No, we had discussion after it was moved and seconded, unless there's anyone else who has more discussion.
I'm going to give Dr. Henderson one more comment, and then we're going to move to Dr. Henderson.
And it's just mechanics. We need now to remove the and that precedes the word communication.
Thank you.
Okay, let's go ahead and take the roll.
Susan Buckshon?
Just one quick comment first. I believe now we just created the same semantics problem with you have communication and client relationship and negotiation and dispute resolution. Do we intend negotiation and dispute resolution to be an addition of 2 additional topics? I think we're considering them one topic. Again, the list is not well crafted.
One topic from NCBE, so that would be my recommendation too. Not that we follow that, but that's what they looked at.
So the last and should probably be a slash or something different to indicate that that is a single topic.
Yeah, I'm fine with that change.
All right. So Jackie made the original motion. So are you comfortable with this friendly motion, friendly amendment?
I am, thank you.
I'm sorry to do this, but does that mean that communication and client relationship should also be a slash? I'm just for consistency, because now we just created a.
It's not in the CAPA report, it's communication and client relationship including, and then there's 3 different things related to the client relationship. So I think it's purposely a title of communication and client relationship.
Got it.
What if we use semicolons to separate these distinct topics? I think that would fix a lot of what the ands are creating.
We've also done bullet point lists in the past for the
Yeah,
report.
I was thinking I could do that too.
Either, yeah,
Very
I
open.
think either of those would work.
Audrey, we need to move litigation down from number 4.
Oh, sorry. How did that happen?
And I think now you can also do negotiation and dispute resolution.
Okay, Jackie.
I'm just, it's wonderful to sit with lawyers because this is what we got stuck on. Yes, I am good with these amendments.
All right, Susan
All right.
Botchin,
Yes.
David Boyd,
Yes.
Alex Chan,
Yes.
Charles Dugan, Jeremy Evans,
Yes.
Jackie Gardina,
Yes.
Ryan Harrison, Dr. Henderson,
Yes.
Esther Lynn,
Yes.
Tracy Montez,
Yes.
Judge Reiser,
Yes.
Natalie Rodriguez,
Yes.
Kristen Rosie,
Yes.
Emily Skivoletto,
Yes.
Karen Silverman,
Yes.
Mylin Spencer.
Yes.
All right, motion passes.
Great, thank you. Okay, so on this topic, I'd like to just turn our attention to one more iteration. Obviously, we just discussed the subject matters. We discussed the skills. One of the guiding principles and questions we've been asked is if we can give some recommendation and some guidance around the percentage of skills versus subject matter that we believe would be beneficial on a future exam. And I don't believe, Amy, we have we had a short part of the first presentation on it. I don't think we have any specific presentation. I wanted to open up the topic to conversation. Is that accurate? Amy, is there any additional information at this point we want to share?
No, that's it. I mean, I think the question was posed to Dr. Merritt, and she made a general suggestion in terms of that proportion. But yeah, we have no other material to present on this. Before I take the first question, I do want to say that as I think about this issue, I think about it as our desire to lower the amount of memorization, which I think is something that we saw through CAPA and been part of our conversations over the last few months. And so the need to increase the skills and lower the subject matters is part of that memorization. So I'm hoping to have a dialogue and maybe come up with some kind of consensus as a group, what we think would look better on the next round. So Emily, with that, you're first in line for questions.
So I guess this is a harder one for me, and I'm not really sure kind of how I feel about it, but I guess as a starting point, I'm thinking about the distinction, if there is one, between the weight of the test and the weight of the score. Meaning that, are we going to have, like, you know, Dr. Merritt said, let's have 100% skills and 100% doctrine. And I get how we would, all of our questions would probably involve one of the 8 topics of legal topics, and then one of the skills. I mean, we could absolutely do that for this exam. But then I get that 100%. And then she was talking about the trial grid for an example of showing that the trial grid was probably 2/3 skills, 1/3 subject matter knowledge. But I other than that, I haven't heard any other percentages or like what would be good. So I'm going to rely on Tracy and Dr. Henderson and others to sort of inform that. But am I correct that we're really talking about the weighting of the score? Like, we could have it throughout the whole exam, but we're talking about the recommendation of how we think the score should be weighted. So I guess that's also my question. Thank you.
So I don't have any answer to that question. I actually grappled with the same thing. And I believe that we're probably best served by just describing through a motion or through our recommendation, specifically what we feel, whether that's weighting of the exam itself in time, in grading, and whatever it is. So I think let's just be specific in what our recommendation is. Tracy?
So I would suggest a general recommendation that if the commission so determines that more weight would be put on a skills assessment type questions. What again, I have seen in past practice is a written multiple choice maybe gets 40% and a clinical performance practice, et cetera, type test gets like 60%. Then you can leave it up to the test developers to then take it maybe the next step further, if so necessary. But I would just keep it very general because really, once your committee that develops the exam starts writing questions, that can give a sense of how these areas are measured. Because really, as Dr. Merritt mentioned, when you have a knowledge, there's also an assumption that you can apply that knowledge, which takes you into skills. So even though you may have a written multiple choice test, it's still going to be assessing some level of skill. Just like your skills test, you have to have the knowledge in order to perform or write or draft. So I hate to think of this as we're separating out rather than just maybe weighting different exam components. That's my thought.
Susan?
I'm troubled by a couple of things here, most of which starts with the concept of reducing this to numbers when we don't even know what we're comparing. When we say 40% multiple choice, 60% skills, we don't even know what the question types might look like. To weight something we haven't seen seems inappropriate to me. I'm also deeply troubled by, it seems to me to be an very artificial construct to say that skills and substance can be tested separately. Those of us that work in the legal education field, I think, would probably dispute that. And our experience would be to the contrary, that they're rather closely integrated. I wonder if instead we might help the test designers by, rather than giving them an artificial number that's based on test questions we have not seen, give them guidance in terms of, we prefer that memorization be no more than 10% of the test. We prefer that test questions be primarily performance test or skill based and that the test avoid as much as possible traditional multiple choice or traditional essay format questions. If some sort of guidance on the type of questions and guidance on memorization, if that's really what this number is supposed to get to, I feel like we might be better off to make recommendations on those specific things instead of trying to reduce it to a number.
Thank you. I think that so far that appears to me to be the direction from the last few comments that people are most interested in. So thank you for laying it out like that, Susan. That was helpful. I do think that I also feel that there's some arbitrariness to it that's uncomfortable. And the idea of coming up with more weight in some areas on skills, for instance, and reduction. I don't even know that we would need to give a percentage, but use words that would allow us to express that we believe a reduction in memorization is an important factor, may be a direction that the group would be willing to go. Dr. Henderson?
Thank you. And I'm in accordance with what you've just outlined. I think that this is a very hard question to deal with in the absence of a plan for the test. We don't know we don't know what the different parts of the test we don't even know what item types are on the test, what the portions of the test would each be designed to assess. I think that it's just better to actually, the speaker this morning talking about 100% of the test in skills and 100% of the test in knowledge resonated with me. I do believe that every question needs to be cast in a context that requires application or problem solving in one way or another, and drawing on doctrinal understandings that pertain to the issue that the question addresses. So I agree with very general guidance at this point.
Any more comments or questions? Based on that conversation, does anybody want to make a motion specific to general guidance around those points?
Sorry, these are just my notes, so I'm.
Mr. Chairman, would it be possible to have the motion read before?
Yes, when we get, Jeremy, when we get to a motion, if that's where we go right now, it'll be read out before we vote on it. Yes.
Thanks, Josh.
Sorry, if it's throwing you to see my notes, I will.
No, that was helpful.
That was helpful.
I think it is. I mean, I think we need to make a decision here as a group if we want to take this direction and add this motion to the other two that we passed today as part of the recommendation. If not, it'll be tabled to next meeting in the beginning, which is I'd really like to focus on non-exam pathway. So I think it would be useful to try to hash this out now if people have additional comments. Tracy.
I like the idea of providing general guidance. I'm not sure if we can tackle it all now, but we can try. If maybe we could just start with that list of, well, we want to limit memorization. Gosh, now I'm stumped on the rest. But something like that. I do agree if we maybe just bullet out some guidance.
So let's
as a motion.
Okay, I was about to move on and come back to this when with maybe some draft language, but it looks like we have two more questions. So or comments. Let me take those, and then we're gonna if we haven't moved the ball further, we're gonna move on. Emily.
So this is hard because we're lawyers and I'm trying to craft a language, but I'm basically, what I'm sort of doing is a move to recommend that the percentage of exam knowledge and skills be determined after the exam is more complete, but generally recommend that and then insert list here, that the memorization be limited to roughly 10% of the exam, that skills, the testing of skills is weighted more heavily than the testing of knowledge, and that every question should require application and problem solving and doctrinal understanding. And then Tracy Montez, who does motions better than I, can go from there.
So Karen, unless you're ready to address it, what I think I'd like to do is have Amy turn to the next topic, and we can start a conversation. We can come back to this and try to get some language actually drafted that people are comfortable with. So let's do that, and we can come back to it. Otherwise, I think we'll spend a lot of time trying to get through language here. Amy, do you want to, let's move to item B on the 2B on the business agenda, which is our discussion around exam requirements for out-of-state and foreign attorneys. it would probably be helpful if you can kind of give us a just background on where we are today, and then we can start a discussion on changes or that we may consider.
Absolutely. All right, to begin with, these are the requirements for foreign educated attorneys, as and I'll also describe in this process the requirements for foreign attorneys that have been licensed to practice in their home jurisdiction. So to start, a foreign law degree must be determined to be a first degree in law. That is a law degree that's equivalent to a US JD degree, or that meets the educational requirements to be admitted in the country from which an applicant is coming from. So once that is established, and it happens through the evaluation by an agency, then if that determination is made, if an applicant has been admitted in their foreign country, he or she is able to sit for the California bar exam for the 2-day exam. And a certificate of good standing is needed for documentation of that. If an applicant has not been admitted to a foreign country, and it's determined by the evaluation agency to possess a foreign first degree in law, then that applicant will need to submit official transcripts to the state bar certifying that they have completed a US Masters of Law, an LLM degree, or completed 1 year of legal education in an LLM program based upon 20 semester units in an LLM program from either an ABA or accredited law school in accordance with the rules, accredited or registered law school, excuse me. Now, foreign educated applicants that do not have a first degree in law must complete their legal education in the US by earning a JD, again, from the same law schools, either ABA, California accredited, or registered law school, or even by completing their legal education requirements through the law office study program. So these are the requirements for foreign educated attorneys. Next slide, please. As for US attorneys from other states, US attorneys who've been admitted for 4 or more years preceding the first day of the bar exam that they wish to take can elect to take the 1-day bar exam. So we require documentation to satisfy this requirement, but anybody who's, again, had at least 4 years of education is eligible to sit for the 1-day bar exam. All right, and then in terms of how many attorneys we're talking about. So, one of the things that we're considering right now is how to treat out-of-state and foreign educated attorneys under the new, with a new California bar exam. Audrey will speak to the volume of applicants. Next slide, please.
Oh, hopefully everyone can see these numbers. It's not a very complicated data set, but you can look at this 20-year trend, and attorneys from out of state over 20 years is sort of holding steady around 1,100 with a dip last year. But what is growing over the past 20 years is that foreign JD attorney category. So we are seeing that trend up even during our pandemic testing. The number of foreign JD and attorneys testing has been trending up over time. So I'm just calling your attention to those 2 columns, looking at that over the past 20 years as we move toward a recommendation here. The next slide isn't super informative beyond this. It's just tells you that the bulk of the test takers are from California law schools, and then of course the out-of-state law schools. And you can see there again, out-of-state attorneys, and then the foreign JDs and attorneys trending upward in the very small percentages of law office study and the other category. So I don't know if it's better if people want to look at the prior slide a little longer to see those numbers. Again, it's not a very complicated data set, but it is helpful as we move forward. Any questions?
No, I think, and Amy, please stop me if you don't think this is the best path. I'd like to split them for the conversation. And I'd like to start with foreign attorneys. We obviously, you walked us through what is currently the rules around foreign attorneys. Are there any thoughts on or reasons why we think there should be changes to that rule based on the information that we've received so far being on this commission and understanding the current rules? Yeah, Judge Reiser.
So if I understand this correctly, if someone, let's say they've been practicing in a common law jurisdiction, I'm going to pick one out of the air, New Zealand, for 20 years with no ethical issues, they're first evaluated in terms of their degree, and then they have to sit for the 2-day California bar exam?
Correct.
Well, that doesn't make sense.
What, which part of it doesn't make sense, and what would your suggestions be?
So if someone, because this is a finite rule that says regardless of where they've been practicing, regardless of the rules, regardless of their law school education, regardless of how long they've been practicing, that they're still going to have to sit for the 2-day California bar exam. And it just seems to me that there ought to be more discretion in the evaluation agency to say, no, this makes no sense at all. This person has been working full-time as a barrister or solicitor or whatever you want to call it in a comparable jurisdiction with no ethical issues for a boatload of time. There ought to be some allowance for those people not to have to sit for the full boat bar exam.
Jeremy?
Yeah, I was just going to add that there is a way for out-of-state attorneys to do that, and that's through the registered in-house counsel process. Now, understandably, that's only for one client, one company, but I'll just add that in there from the out-of-state standpoint.
Yeah, I think, and I don't know that there's a difference. I'll ask Amy that question. We're sticking, hoping to just have a conversation about foreign attorneys at this point. Amy, is there any distinction in that process for foreign versus out-of-state in-house counsel process?
No, there isn't. I mean, foreign attorney, I also want to correct one quick thing. The foreign degree of law that needs to be evaluated is only for foreign educated. If you've been practicing in another country, admitted in a foreign country, you don't need to do that. But in terms of their ability to register for registered in-house counsel, they have to have been admitted in the US in order to comply with that or sit for the California bar exam for the 2-day as a foreign attorney coming to practice in California.
Neil?
I was just going to point out that maybe this decision point would be informed by another decision point, and that point would be whether or not our test actually tests for California law. That might change the evaluation of an exam in this context.
So should we go back to the subjects? Because I think some of that was covered when we talked about the 13 topics, which ones were relevant. It had some California specific law within that. And let me go back to that. So the professional rules of professional responsibility is one area that covers both ABA model rules of professional conduct and California rules of professional conduct, as well as the civil procedures, which include federal rules of civil procedure and California Code of Civil Procedure.
Yeah, I'm not. I'm trying to process that that distinction that Neil was making. I mean, for instance, constitutional law. I think a lot of these topics you probably would need if you're coming from foreign educated to practice in any state, and then obviously specific to California. Jackie, your thoughts?
And I was going to echo Neil, but in a slightly different way. It seems like the question is, should they have to have a pathway to licensure? Should they have to go through something other than simply waiving in? And we haven't made a determination yet or a final recommendation around multiple pathways to licensure. So the question may be, do foreign educated and attorneys who have practiced in foreign countries need to have a pathway to licensure? So right now it's written, or we're asking the question, should they have to sit for the 2-day bar exam, as if it exists as it does. This list right now doesn't reflect the list that we voted on. For example, professional responsibility is not going to be part of the exam as we have recommended to the bar taker or to the exam writer. So I guess the question for me is, would this come after we've made the 2 decisions about the pathway, and we would make a determination whether or not they don't have to take a pathway, both pathways are available to them, one pathway is available to them, or an alternative pathway is available to them?
Amy, the issue's a little muddled for me. Maybe it's just me. Can we go back to the slide that we started with? Because I'm having a hard time around foreign attorney, foreign educated attorney, foreign, a licensed attorney. And it feels like that's getting a little mixed in this conversation.
Sure. Okay, so we're back at that slide.
So
a foreign educated attorney requires this evaluation to make sure that we have the equivalency of a JD. So that's the one difference between those two. Distinction between a foreign educated applicant and an applicant who's been practicing in a foreign country. An applicant who's been practicing as an attorney in a foreign country is able to sit for the 2-day bar exam and does not require further education, unlike the first, unlike somebody who's foreign educated. And that's that distinction.
Jackie, you still have your hand up?
Well, just to clarify, Amy, is it assumed every attorney who comes in seeking this pathway has a foreign degree of law? Some of them are not licensed, and some of them are licensed and been practicing in the foreign country. Those who are not licensed must have their degree evaluated by the agency. And if they were not admitted, they have to get more legal education in the state of California. If they have a foreign education and have been admitted and were practicing in another country, they do not have to get an evaluation, and they can pass additional education and go directly to the bar exam.
Correct.
Okay. Amy, Emily, you have a question?
I was just going to weigh in 2 things. One, looking at this slide, I feel like the first line and the third one are together, they're linked together. So if you, because this is how our LLMs do this, right? They have a foreign law degree, but not admitted anywhere else. They want to come and get an LLM so that they can get what is required in order to sit for the 2-day bar exam. But they have to have their first foreign law degree looked at to make sure it's the equivalent of a JD. And we also have people who are admitted to practice and have been practicing law in another country that come to get an LLM degree just to get an LLM degree, and also to take some bar classes, but they could take the exam without having to do that. So I was just going to also echo Jackie that I do think that I understand we want to kind of keep going and get the points that we need to get for the recommendations, but this is I would rather have this conversation after we've talked about the full path to licensure, because I think that is going to impact a lot of what we're talking about here, rather than just whether or not it's the exam.
Yeah, I think that's a very good point. I'd like to, if possible, continue the conversation a little bit, but I do see the logic in tabling decision until we get through the entire path or paths. Can we just go back to Judge Reiser's question earlier? I think one of the questions we will need to answer, whether that's today or at one of our next meetings, is kind of the second bullet point here, which is if the applicant has been admitted in a foreign country, they're eligible to sit. And I think for the 2-day exam, I think what Judge Reiser was saying is, is that still, do we still feel that that's the right path for them? Or is there any additional reciprocity that we should be considering for someone who's practiced over a certain number of years, who clearly has a foreign degree and a foreign license? Any thoughts on that?
Amy, this is Alex. Is there a jurisdiction in the United States that would accept foreign attorney without requiring them to take the bar exam?
I can't answer that, Alex. I have not done that research in terms of how foreign educated attorneys are treated. Yeah.
Okay. My understanding, however preliminary, is that there isn't such a jurisdiction. So if we do something like this, we would likely be the first ever state to accept a foreign attorney without requiring them to take the bar exam.
And in fairness, Alex, I don't think anybody is suggesting that that would be the answer. Although I do think, Amy, for our next meeting, it may be useful to pull that type of information. I think the question becomes, is it a full 2-day California bar exam, or is there maybe something less than that? Or maybe the answer is that this is still the best approach. So unless we have more comments on foreign educated attorneys, I'm going to suggest I'm going to take a couple more comments, then we'll table this until we get through the non-exam pathway also. Susan?
Just sort of one other consideration here is the judge's question was actually quite narrow. He said in a comparable common law jurisdiction, and that's a huge if and a huge qualifier. And I'm not sure how we would expect our bar examiners to make the determination of which jurisdictions would qualify for that. And so there would have to be some evaluation and further definition and help provided to the bar examiners if they were to be expected to determine which jurisdictions are sufficiently common law.
And Susan, just to clarify, we do that now. So we, when we get foreign educated applicants from foreign attorneys, that's one of the things we look at is common law is part of that requirement. And so we have dedicated some time to do that research and rely on that as part of our determination. So Josh, just to go back to, I think what you were suggesting, what we could do is table this topic on how to treat foreign attorneys. We'll conduct some background research on how other jurisdictions treat these applicants in terms of the requirements, and then bring that back. But this sounds like a topic that we'll revisit once we're done with the non-exam pathway as well.
Okay, thank you. I think that's going to be the best use of time.
Okay.
What I'd like to do for the remainder of our time, I know we're on a tight schedule. I'd like to take a couple of minutes to talk about, and again, I think we'll end up with the same result as far as tabling the issue, but I'd like to take a couple of minutes talking about out of state and reciprocity and get some thoughts of the commission. And then we're going to go back to the motion that we were looking at regarding trying to weight skills and knowledge and content. So with that, Amy, can you just quickly, one more time on out of state, give it just a 1-minute review for folks to start a conversation?
Sure. So U.S. attorneys who've been admitted for 4 or more years, immediately preceding the first day of the bar exam that they want to take, can select to take the 1-day exam. And that is required for licensing in California. There's no alternative. Either sit for the 1-day bar exam or the 2-day.
And in having this conversation, our rules around reciprocity, how do those affect other states' rules around our attorneys being able to practice in those states?
So we don't have a reciprocity protocol here in California. So attorneys from other jurisdictions must take the bar exam in California. And are you asking about California attorneys that go to other states?
Yeah, my understanding is that there are always conversations that occur, and that there potentially would be more open minds. And I thought that was something that we should at least know about and consider.
Mm-hmm. So at one of our meetings, we shared the admission on motion requirements around the country.
Yep.
Should I share those now?
If you
And just
could.
as a-
I think-
Yeah, just as a
that'd be helpful.
reminder. Whoops, instead of share screen, give me 1 second. There we go. So again, let me remind everybody what this looks like around the country. So if you see here, let me move this. This combines the notion of ABA, whether the restriction around reciprocity or comity is restricted around being an ABA approved law school or not. So the states here that are highlighted in red are jurisdictions that allow reciprocity, will allow admission on motion. That is, the attorney does not have to take the bar exam, but reciprocity is required. And the applicant must be an ABA approved law school graduate. The blue jurisdictions here allow for comity. So that is, no reciprocity is required. And again, the applicant must be an ABA approved law school graduate. For the jurisdictions in green, they no reciprocity is required, and they're open to non-ABA law school graduates. Those jurisdictions in purple allow non-ABA law school graduates to enter or to be admitted on motion, but reciprocity is required. And then the white states there, or light yellow, they must be an ABA approved law school, and they do not have a position on reciprocity. And obviously the gold ones, applicants must sit for the bar exam, and we're among those states.
Thank you, Amy.
Sure.
So that's a good background for us understanding where we are today from requirements for the state of California. The question that I think we're going to answer, I'd love to hear people's thoughts now on additional information that would be useful. The question we're going to try to answer at the next meeting or the one after is, are there changes more restrictive or easing on what we believe, or we would want to make a recommendation as a commission that changes should be made or should be considered? Any thoughts on that now, or any additional information that you'd like the bar staff to consider and report back on that would be helpful in your decision making? Judge Reiser. You're muted.
So Amy, these green states, Washington, Minnesota, Wisconsin, Iowa, Texas, et cetera. What this means, I think, is that if a California lawyer from any law school in California is a subject of a motion to admit in those states, then within the discretion of those states, they can be admitted as a practicing attorney in those states.
Absolutely. The caveat also is that there might be some course requirements, like education, continuing education courses that are required in those states. But yes, they would be admitted on motion, meaning they do not have to sit for a bar exam in those jurisdictions.
And so my follow-up question is, do these states have a criteria or multiple criteria for how long the applicant needs to be admitted in California, or does it variable by state?
It varies by state, but I could report back on that at the next meeting if you'd like.
I would like that.
Okay.
Yeah, I concur, at least for Texas, even though you can be admitted by motion, you are required, I'm admitted in Texas, you're required to practice or have at least 5 to 7 years of practice under your belt before you can even be considered to be admitted in that state without taking the bar exam.
Jackie?
Yeah, I had a similar question. I'm wondering if there are any limitations in other states regarding attorneys who have, and how it's phrased in those other states, disciplinary actions against them, or have had other issues, whether that erases the ability to be in on motion, whether it sets requirements up for them, et cetera.
I believe that's a separate consideration. There's the legal education that's required, and that's what this would satisfy. And then separately, there all of the there's a moral character determination or assessment that has to be made, and that's a separate part of the licensing requirement.
Yeah, and I think that's my question, which is if we're talking about saying it may not be required for you to take the California bar exam. I'm wondering if there's situations in which, yes, I've been practicing in a state for 5 to 7 years. Yes, I'm eligible to be waived in if that's what we decide to do. But I've also been subject to disciplinary actions or other types of things that might trigger a more rigorous path to licensure within our state.
Amy, you want to respond to that?
Sorry, let me go back to one piece. So the question is like, do you have to be an attorney in good standing for coming from these jurisdictions?
I think it's, well, and let me just phrase it differently. If we were to go in the direction of not needing to take the California bar exam if you met certain requirements, such as passing the bar in another state, having practiced for 5 or 7 years, or whatever the case may be, would there be circumstances in which we would remove that ability to waive the California bar exam or waive some other pathway to licensure? And would we want to set those limitations up, or do we have the authority to do that, or recommendations around that?
I think that's the kind of recommendation that the court's looking for, is what kind of requirements we want to suggest here. And it sounds to me, Jackie, what you're suggesting is the potential of ensuring that somebody is in good standing from another jurisdiction before they enter into California.
Yeah, I mean, if we go back to that public protection idea, what would be the basis for saying, you know what, in order to protect the public, we think you need to go through this pathway to licensure, whatever it may be. Simply checking off the box of a legal education and checking off the box of having passed the bar in another state isn't sufficient for in these circumstances.
Okay.
Emily?
I guess it would be, if we're going to talk about this more at another meeting, it would be helpful for me to understand, I guess it's the pros and cons, but what do we care about most, right? Obviously, if we care most about consumer protection, that's what the state bar is sort of designed to do. Obviously, we have other things that we're concerned about, but are we trying to allow our law school graduates to go to another state? Are we trying to allow longstanding practicing attorneys in another state come to California? Like, do we like both of those things? What is it that we're trying to do with this issue? And at the same, I mean, so to me, that's one issue. And then how we do it, is it by exam? Is it by, a moral character check? Is it, a California specific exam for out-of-state attorneys? Like, all of those are options, but I'm confused about kind of why, not confused, but I think there's a lot to why would we be doing this? So. Yeah,
I think we'll try to put some thought into it and see if we can't set up the question a little better. I mean, I believe that this is something that we've covered and talked about a number of times. There's numerous factors, fairness, increasing access to justice, creating more opportunities for both attorneys in California and out of state. And all of that is always balanced against public protection. And so it's that is the debate I think we're going to need to have, and then figure out, is the system we currently have one that accomplishes all of that, or are there changes that we would recommend? And again, I don't believe that we'll be ready to do that today. I'm going to take one or two more questions. Then before we end, I want to go back to the motion that we were drafting to put it on the table and try to close out as close to 2 o'clock as we can. Tracy?
Okay, I'll make it really fast. At Consumer Affairs, we struggle with the same issues that you just mentioned. And what we remind our boards and bureaus that consumer protection is number one. So that's always our first goal when we're looking at reciprocity issues. The accessibility, transportability, all of that is secondary. So in order to prevent artificial barriers to licensure, we basically start what is the minimum needed to protect the public. And we whittle down that to a lot of things like just having a, say, law and ethics exam for many of our professions. If you're out practicing, you're in good standing, you've been out there for at least 3-5 years. It depends on our programs and our professions. No problems. You come into California, then we assess what is the minimum knowledge you need that's unique to California. And that becomes sort of the criteria for determining reciprocity. Some licenses, you don't need it. It's a national exam, you're fine. Others say, nope, we've got some very specific California health and safety laws. So I'll just leave you with that to really, again, prioritize what the intent is. And then I do have a motion for the next one. So when you're ready to move on to our other item, I have a motion for you.
Josh, anything else you want to raise here that we can answer in terms of the how to treat attorneys from either foreign countries or other jurisdictions?
I don't think so. I think that answers most of the questions. If we can bring some of those issues back at our next conversation, that'll be helpful. I do want to focus a little bit on the comment Neil made earlier about, if there is an alternative to it, how much of it is California based? Obviously with the out-of-state folks and the one-day exam, that's what's most important. But if we can just set the table for the next meeting on those topics, Amy, that'd be really helpful.
Okay, will do.
Okay, let's go ahead then and move back to Tracy. I think you said you have a motion based on the conversation we had earlier around skills and knowledge.
Tracy, I'm going to share, and just because it's not exactly what I think you were going to read. Donna has made a couple light edits before she had to step out. So I don't know if you want to read through this. First, I also have the original one that you sent me.
Can someone read this?
I'll read it. It is recommended that in developing the exam, the need for memorization of doctoral law be limited. There be a focus on assessment of skills and the application of knowledge and performance of associated skills for entry-level practice, the precise weight of content knowledge versus skills to be determined after the development of the exam. Yeah, I'm fine with that.
And then this, the commission further recommends transparency on topics and rules to be tested, including the extent to which candidates are expected to recall such topics and rules or possess familiarity with such topics and rules. That was based on some of Debbie Merritt's recommendations.
And Audrey, is that considered, that additional sentence considered different than the memorization?
Yes, in terms of us being transparent along the way, I think it was important to call out.
Okay.
I agree. So I move this forward as a motion.
Okay, do I have a second?
I'll second.
I think that was Emily. Comments, conversation? Judge Reiser. You're muted.
I keep having that same problem. So, sometimes it's not what you say, but how you say it right. I think there needs to be a de-emphasis on memorization, right? And so when you say the need for memorization be limited, that doesn't really provide guidance. What does that mean, right? And while it does kick the can down the road, with respect to weight, I think we ought to say it in a positive way, and that is we want to emphasize the application of legal skills to problems and issues presented, de-emphasize memorization and traditional, I think Susan said it better earlier, de-emphasize traditional essay exams and multiple choice perhaps, just to provide some guidance, which, you know, I mean, this is fine. It seems to be stark.
What if I could change this to in favor of a focus on assessment of skills and application? Would that get to some of what you're saying?
It would.
I agree with Judge Reiser. I think if we could just say what we're trying to achieve first, and then, you know, rather than an emphasis or an overemphasis on memorization of doctrinal law, that would maybe help us. It's just really just flipping it.
So not the way I have it.
I would reverse the order of the points. I would say it's recommended that in constructing the exam, we emphasize the application of knowledge and performance skill, you know, that, right? So state the emphasis that what we do want, and then contrast it with what we don't want.
So Audrey, just go back up. Sorry, this is Tracy. Just go back up to your draft and just say it is recommended that in developing the exam, then go down and cut out no, sorry, it's still in your draft.
Yeah, I think I'm trying to flip it here. Is that what you mean?
Okay, yes.
Right. Like this.
Yes. And we could.
Okay.
Probably need to read it for Jeremy because I don't think he's at a computer.
Yeah, we'll do that again. Judge Reiser, you had a comment. I think you felt that the word limited wasn't strong enough for what you thought needed to be portrayed. Do you have a suggestion of another word there that we could use?
I would say de-emphasized. And the last and I would say with, so that we put them hand in hand. There we go.
Tracy, are you okay with the friendly amendment?
Yes, let me just read this. It is recommended that in developing the exam, there is a focus on assessment of skills and the application of knowledge and performance of associated skills for entry-level practice. Could we just say, comma, de-emphasizing the need for memorization of doctrinal law and get rid of de-emphasized at the end?
Beautiful.
The precise weight of the exam, the content, knowledge versus skills to be determined after the development of the exam. Yes, thank
you. Judge Reiser, you have another question?
Sorry, I just didn't lower my hand.
Okay. Dr. Henderson.
Thank you. Just pointing out that the second sentence of the motion is not a sentence.
I have the same comment and it makes it sound like it's that the assessment or the assessment of skills and the application of knowledge is also on the same level. So I would say it is recommended that in developing the exam, there is an increased focus on assessment of skills. And then maybe say, and also the applicant, but I don't want increase to modify that, so I don't know how to do that. And I don't think I've reached Dr. Henderson's point, but.
So his points with this sentence, which we can come back to, right? Okay.
I apologize. I'm gonna have to drop off. I think you still have a quorum if I do. And for whatever record, I would support this concept once we articulate it.
Thank you.
Apologies.
I'm in a similar position, but I also support where we're going with this.
Are we just saying in the second sentence, the highlighted sentence, I mean, are we just saying should be determined?
Yeah, that will be determined. That's what I was going to say too. Is that fine?
I mean, it's a recommendation. I don't really want to put will in a recommendation.
Right, and
Okay,
I don't want to water it down too much, right? So I'm consistent with the discussions that I've heard today. In that first sentence, I would say there's a significantly increased focus as opposed to, you know, a minor increased focus on assessment of skills, right? So I think we're talking about significantly increased focus on assessment of skills and not just some tweak.
I go back to Tracy. Tracy, are you okay with these friendly amendments?
Yes.
Okay.
Significantly increased.
Let's just deal with the first paragraph for a moment. Are there any questions, any more thoughts, discussion, friendly amendments on the first paragraph?
I think just as a general thought, would there be any implication when we say de-emphasizing the need for memorization? Would there be an implication that we're not going to be focusing on essays and MPEs and more on performance tests? Or dictate that either the essays or the MBEs would be eliminated? I just want to make sure I understand the general guidance of this motion.
Yeah, it's not our intent to get into modality and format. I think that's going to be more part of the development of the exam, but a broader statement on policy.
Okay.
Looks like we have two more comments. Emily?
I'm just trying to set off the assessment of skills. Yes, right there. I would say, and also, or we'll say in significantly increased focus on assessment of skills and then also, or I don't, it's not then, but we need something there so that the significantly increase is not modifying along with.
Okay.
Maybe not the and, yeah.
Yeah.
Okay, I think we should be, any comments on the second paragraph? Okay.
I'm sorry, I do have one more thing. As you were right, Josh, as a recommendation, can we say that there be a significantly increased focus? It is recommended that.
Like there should be here as well?
Yes.
Yeah. Susan?
On the second paragraph, do we need to be or want to be clearer about whether or not this includes providing the actual rules? Because that was a significant portion of Dr. Merritt's discussion this morning. And I wonder if this, when we say transparency, do we need to suggest that we intend for that to be an actual rule book?
Again, it's like peeling an onion here, right? I mean, we could keep going. I think that's a decision that at least I don't feel comfortable making. I don't have that enough knowledge in test making to decide. I don't think, but I leave that to the group if they disagree with that, to dig into, whether or not there's transparency, letting people know what's going to be on it versus specifically providing a document that has, 4 corners of what's going to be on it. I think that's going to be a future decision. Tracy?
I was just gonna say, I agree. I think there's enough research that we can give them to guide them in that direction, but I think we need to leave it up to the test designers.
Okay, let's go ahead and take a vote. Amy, you calling roll?
Yes, I am. All right, Susan Bakshian,
Yes.
David Booth,
Yes.
Alex Chan. Alex Chan. Charles Dugan. Jeremy Evans.
Yes.
All right, Jackie Gardina,
Yes.
Ryan Harrison. Dr. Montez,
Yes.
Judge Reiser,
Yes.
Natalie Rodriguez, Kristen Rosie, Emily Skivoletto,
Yes.
Karen Silverman, Mylin Spencer,
Yes.
Dr. Henderson,
Yes.
Esther Lynn.
Yes.
All right, motion passes.
Thank you, Amy. All right, folks, that was I really appreciate everybody's time and focus. That was a lot we got accomplished and needed to get accomplished. We have 2 meetings coming up on May 5th and then on June 9th, where we'll focus on recommendations for a non-exam pathway. And we will once again deal with out-of-state and foreign educated attorneys. With that, thank you. I think we can adjourn. Amy, any other business?
No, just a reminder about our next meeting. It's scheduled for May 5th. And you've already mentioned this already, that it will be a full commission meeting.
Fantastic. Okay, thank you, everyone. Appreciate it. See you soon.
Thank you.
Thanks. Bye.
Bye.